Courtship and marriage.
Amount of the bride price. The suitor came with presents to the parents of the girl. Most writers see in this a survival of the purchase of the bride. The name of this gift, Terb Karani Talatu, is undoubtedly connected with the name of the bride, Marb Karani Talatu. This present, or bride price, differed greatly with the circumstances of the parties. Both money and slaves were given, but a simple sum of money was more common. In cases where the bride was rich or highly placed, the amount seems less. A very usual amount was 10 shekels, but we have examples from 1 shekel up to 3 minas. The code assessed it at 1 mina of silver for a patrician and 1/3 of a mina for a plebeian. Its disposal. Without this bride price, the young man could not take a wife. Hence, it was expressly secured to him by the code if his father died before he was of age to marry, and reserved as a first charge on the father's estate. There is some evidence that a woman might make this present to her future husband, but that may have been because he was too poor to make it himself, and she found him the means. As a rule, the parents gave this money to the bride, but we are not in a position to say whether they did so at once, on the consummation of the marriage, or on the birth of a child. The suggestion that it was her Morgengabe remains without support. Certain it is that it was not returned always. In the contracts, it seems to be given to the bridegroom with the bride. On a wife dying without children, the husband was bound to return her marriage portion to her family. But if the bride price which he had given for her had not been returned to him, he could deduct its value. On a divorce, he was bound to let his wife have not only her marriage portion, but the bride profs paid back to him. If there had been none, he must give her a fixed sum instead of it. Its presentation, from the phrase books, we may gather that there was a sort of ceremony about presenting the bride pace to the father. It was placed on a salver and brought in before the parents. This was probably a part of the ceremony of betrothal. If the father rejected the suitor, he was bound to return the bride price offered. A curious section of the code enacts that, if the suitor's comrade intrigued to break off the match, he was excluded from marrying the girl himself. Penalty for breach of promise. If, after he had brought in the bride price to his prospective father-in-law, the suitor took a fancy to another girl, he might withdraw from the suit, but he then forfeited what he had offered. If this really was the result of having taken a dislike to a plain girl, we may suppose that such a maiden might accumulate several bride prices and so acquire some wealth. This may explain Herodotus's idea that the handsome girls made a dowry for the plain one, but there is not a shred of evidence for their doing so in the way he suggests. A girl was a virgin when she was married. The preliminaries of marriage, of interest in the later Babylonian texts, is the fact that the preliminaries of the marriage are more fully illustrated. Thus, we read of the wedding of the daughter of Neriglissar. Nabu Shumukin, the Arab Biti of Nabu, judge of Ezida, spoke to the king Neriglissar, saying thus, "Give to me, Gigitum, your young daughter to wife." The tablet has only preserved a few lines from which we cannot be sure that the marriage took place. The tablet was called a duplicate of Ezida, showing that it was preserved in the Nabu temple at Borsippa. The following case is one of the clearest. Negotiation of a father for his son, Nabu Narkarin, son of Balab Karone Idin, grandson of Ardi Nergal, spoke thus to Shumukin, son of Mushalamu, saying, "Give me thy daughter in Asejel Banat, the maiden to wife, for Ubalatsugula, my son." Shumukin listened to him, and gave his maiden daughter in Asejel Banat to Ubalatsugula, his son. He gave also 1 mina of silver, 3 female slaves, named, and house furniture, with Ina Esagil Banat, his daughter, as a marriage portion to Nabu-Nadin Ab Karoni. Nanakisharat, the maid of Shumukin, in lieu of 2/3 of a mina of silver, her full price, Shumukin gave to Nabu-Nadin Ab Karoni out of the 1 mina of silver for her marriage portion. The deficiency, 1/3 of a mina of silver, Shumukin will give Nabu-Nadin Ab Karoni, and then her marriage portion is paid. Each took a writing. Here the father negotiates for his son. There is no evidence of any bride price being paid. But the examples of this kind of document are too few for us to establish any fixed conclusions. In the following case, something very like it appears. Negotiation with a mother for her daughter, Dagilalani, son of Zambubu, spoke thus to H.B. Karen Ukama, daughter of Negal Idin, son of Babutu, saying, "Give me thy daughter, Ladubashini, she shall be my wife." HB Karen Yukama listened to him and gave him her daughter, Ladubashini, to wife, and Dagilalani, in the joy of his heart, gave to HB Karen Yukama for Ladubashini, her daughter Anna Eli Beli Amur, a maid, for half a mina of silver, and a mina and a half of silver to boot. The day that Dagilani shall take a second wife, Dagilani shall give Latubashini a mina of silver, and she shall go back where she was before, with the cognizance of Shumadin, son of Inaishiter, son of Sindamaku. Here the man himself negotiates. The mother gives the bride. Whether he really buys her is hard to say. The mother may have adopted the girl to care for her old age, as was often done. The bridegroom may have compensated the mother with means to adopt another daughter. What locus standi Shumadin had is not clear. He may have been the real father of the bride and so had to be satisfied that she was fairly treated by the change in her position, or his consent to the bridegroom's alliance may have been needed. The penalty set down for divorce is not high and the bride was probably poor. We see she was portionless. In other cases it was as high as 6 minas of silver. Occasionally the deed of marriage also named a penalty for adultery on the part of the wife. Role of the contracting parties, women were given in marriage. The suitor for her hand did not perhaps see her until marriage, but this is not likely, since he is contemplated by the code as capable of having cast his eyes upon another, and so, desiring to retreat from his suit, at any rate he brought presents to her father, who accepted or rejected him. There is no hint that the woman had any choice. The result of this power over the child's marriage was that conditions might be imposed on the marriage. The bride might be required to do service to an existing wife or to the bridegroom's mother. Further, the disposal of property was not entirely free after marriage. It depended upon what the father had laid down in the marriage settlement on his daughter. It was strictly limited to the woman's children, and if there were none, it went back to her father's house. Giving away the bride. In early times, the father usually gives the bride, but in a great many cases this duty fell on the mother. How this came about we do not usually know. The father being dead or the girl illegitimate seem the best explanations as a rule. In the absence of father and mother, the brother as head of the family assumed the duty. The examples of this are common enough. For later times also the examples are numerous of the power of agnates to give in marriage. It may perhaps be deduced that the children in these cases were young. Widows free to dispose of themselves. Women once married were free to marry again of their own choice, whether divorced, separated, or widowed. A betrothed girl or bride, if her marriage were not yet consummated, being seduced by her father-in-law, in whose house she had gone to live, was also free to marry. But it does not seem that women who were yet virgins could choose their own husbands. Even princesses were given in marriage. Consent of bridegroom's father or guardian requisite for a legal marriage. The man was not altogether free to marry. The code contemplates a boy left by the death of his father too young to marry. The brothers, when they divided the father's property, were bound to set aside for him, in addition to his share of his father's property, a sum for a bride price, and take him a wife. It seems probable that men married while still young and living at home, for the code contemplates the bride being brought to live in her father-in-law's house. In later Babylonian times, at any rate, the son could not marry without his father's consent. This we learn from a suit in high life in the time of Cyrus. A high official of the kings, A, brought a suit against B, who was over the house, before the nobles and the king's judges. A accused B and C, an official of his house, of having given a tablet of marriage contract of D, a sister of C's, to A's son without A's consent. Put to the oath, B swore that he did not seal the tablet. Then D was questioned. Then C acknowledged that he had drawn up and sealed with B's seal the marriage contract of D to A's son. The judges ordered D to return to her brother's house. The tablet was to be broken whenever found. If afterward D should be seen with A's son, she was to bear the sign of a concubine. The court of registration. From other examples, the conclusion is inevitable that, if a woman desired to be a full and proper wife, she had to obtain the consent of her bridegroom's father. Thus we read, "The day that the woman A is seen with B, he shall bring her to the wedding house. If she does not say to the master of the wedding house, 'Send for C, the father of B,' then she shall wear the sign of a concubine." Her mother was present at the sealing of this agreement. From this we may deduce that weddings took place at a definite spot, called the wedding house. The name was literally House of the Males, or of the Named Ones, and also House of the Marbain, or Sons of Ancestors. It is clear that this was a registration court, where all who had pretensions to ancestry or were people of position were enrolled. One whose name was found there was a man with a name, also a son of an ancestor. He was probably registered there at birth, marriage, and death. The master of that house was a registrar and evidently could marry people. It was expected in this case that the woman, if she wished to be properly married, would send for the bridegroom's father, whose consent was necessary. Another name for the house was Bit Pir Sodom, the meaning of which is obscure. But, as Ishtar was Belit Pars, the lady of the Pars, we may connect it also with weddings. The bride's dowry. We have seen that the terherb karoni talatu, or present made to the parents by the suitor before marriage, was usually handed over to the bride on her going to her husband's house. There is frequent reference to this essential preliminary. It had to be carefully laid aside for the young man by his mother or brethren if he had not married in his father's lifetime, and was secured to him by law apart from and above what might come to him as a share of his father's property. Otherwise, he would suffer loss in having to find it out of his own pocket when his married brothers had been provided with the means during their father's lifetime. Usually, it was an amount of silver, 1 shekel, up to 3 minas. In later Babylonian times, there is little evidence of the parents receiving gifts. We now and then find it so. Thus, a man gave a slave and a mina and a half of silver for his wife to her mother, but it is not clear whether or not this was to buy her marriage portion. A far more valuable endowment of the bride was her marriage portion. If her father was not alive to give it to her, the duty fell on his heirs, and she had a right to it over and above her daughter's share of his property. Thus we find that the brothers, on giving their sister a share, contract to further endow her if she marries. Her trousseau. We have 1 or 2 lists that show what might be expected as a trousseau by a Babylonian bride. One, which illustrates the code extremely well, narrates first what had been given a notary and nubar of Marduk by her father on her taking her vow and entering the temple of Anunitum. This was his grant to her and was known by the same name as the marriage portion of a bride. It included half a shekel of gold for a nose ring, 2 shekels of silver as a finger ring, another ring of silver of 1 shekel, 1 malumsa, 3 cloaks, 3 turbans, 1 small seal worth 5 minas, 2 jewels of unknown character, 1 bed, 5 chairs, 5 different sorts of things apparently made of reeds. The concubine, Seratum, her stepmother. Unfortunately, many of these renderings are still quite conjectural. It is interesting to note that the father left to his daughter his concubine, who was probably a slave and possibly really the girl's mother. But now this girl is about to marry, and her own mother, Shubaltum, at any rate, her father's full wife, together with her brothers and sisters, give her all this property and cause it to enter her husband's house. They had a reversionary right to her property, since as a votary she could not alienate it from her family. So now they waive their right, as it will, after her marriage, pass to her children if she has any. So they are said to give her what her father had already granted her. Further, they return to her husband the tereb korona talatu of 1/3 of a mina of silver, which he had presented to them. The marriage portion could not be reclaimed by the wife's family at her death if she had children. If she had none, it went back to her family. Nature of the marriage portion. Another long list, also a grant to a votary, is found in 2 documents which contain apparently a complaint of oppression made to the king. Neither is sufficiently complete to be decisive as to the purpose of the letters or reports which are written in the first person, but they are duplicates as far as they preserve the list and in many other long phrases. Here is the list. 4 of gold, 2 rings, 2 dishes carved with karaku birds, 1 dish carved as a lion whose head is of abwood and its border of kuwood, 1 chair of kuwood, 3 chairs of different makes of abwood, 1 oil pot, salah, 1 oil pot containing 200 k bidot otelska of Carchemish work, 1 mixing pot of copper, 1 dupru kegu containing 30 kb. Otelska, 2 kundulu of copper, 1.2.1 for. Although this list is full of words of which the meaning is obscure as yet, one can see the main drift of it. Jewelry, household furniture, pots and pans, and whatever went to the domestic equipment of the house. It is of interest to note that already Carchemish was celebrated for its wares. With these lists may be compared the Tel El Amarna lists given in transcription, with a few hints at translation by Dr. Winkler. They are lists of presents sent by a king of Egypt to a king of Babylon, by Dushrata, king of Mitanni, to Nimuria, king of Egypt, as the marriage portion of his daughter, Tadu Karonipa, and another list of her dowry. The greater part of the names of these articles defy translation. Later, usage during the 4th dynasty of Babylon, the celebrated Michaux stone, records the gift of lands by a father to his daughter on her marriage. From Kassite times, we have a list similar to the above, but not easily translatable. The supposed examples of dowry in Assyrian times are not really such. But in the later Babylonian era, the marriage portion was still given by the father. It bears, however, the name Nudunu, once reserved for the husband's free gift to his wife. The Nudunu in one case is 10 minas of silver, 4 maidservants, house furniture, and the like. It might include sheep and oxen. See also the later Babylonian laws about the marriage proportion. A long list might be made out from these sources of the house furniture, but as before, we do not know what half of the terms mean. Payment of the marriage proportion. There are many examples of receipts given for the marriage proportion received in full. Sometimes it was merely promised. It was not always paid promptly. Law C made a note of this. The father might have promised a portion and even given a deed of gift for it to his daughter. But if his means have diminished, he cannot be held to a literal fulfillment of the promise. He may do what he can. The law adds significantly that father-in-law and son-in-law shall not oppress one another. We find that actions were frequently brought to obtain a marriage portion. We have an instance where the payment was withheld for 9 years. Wife's pin money. A husband might make a settlement on his wife. In the time of the code, this was called a nudunu. It had to be by deed of gift. It might cover income-producing estate as well as personal property, but it was hers only for life. She could leave it as she chose among her children of the marriage, but not to members of her own family. We may regard it as pin money. Her husband's heirs could not disturb her possession of it as long as she lived, but she forfeited it if she married again. The period of betrothal. The betrothed maiden did not at once leave her father's house. This we learn from the code, which enacts a penalty on one who should seduce a betrothed maiden living in her father's house. It seems that on both sides, betrothal took place in early life, and that the arrangements were in the hands of the parents. A father was expected to take a wife for his son. The wedding ceremony, neither the code nor any contracts throw light upon the marriage ceremony, but a tablet published by Dr. Pinches in the Proceedings of the Victoria Institute, 1892-93, reprinted as Notes on Some Recent Discoveries in the Realm of Assyriology, contains certain suggestions. It is very fragmentary and in the form of an interlinear translation from the Sumerian. It is not always clear who are the actors referred to, but we may perhaps take it that the officiating ministers, priests, or elders first placed their hands and feet against the hands and feet of the bridegroom. Then the bride laid her head on his shoulder, and he was made to say to her, I am the son of nobles. Silver and gold shall fill your lap. You shall be my wife. I will be your husband. Like the fruit of a garden, I will give you offspring. Then there is a wide gap. But in the next column, we seem to have a further part of the wedding ritual. The officiating ministers ceremoniously bound sandals on the feet of the newly wedded pair, gave them a leather girdle or strap, and fastened to it a pouch or purse of silver and gold. The further ceremony included placing them somewhere in the desert. Then, turning their faces to the sunset and addressing the man, the minister says, I swear by the great gods, and you may go. He bids him not to put off the garment of Ea, nor something belonging to Marduk of Eridu. Then comes a wide gap, but the fourth column seems to read, until you have settled in the house, until you have reached the city, eat no food and drink no water, taste not the waters of the sea, Sweet waters, bitter waters, the waters of the Tigris, the waters of the Euphrates, waters of the well, nor waters of the river. To fly up to heaven, direct not your wings, to burrow in the earth, set not your dwelling. As a hero, the son of his God, let him be pure. The passage is very difficult, and much of the rendering is conjectural, but the point of the address seems to be that the young man was to go straight home, live with his wife, and be good, as a true child of God. The first column seems to be an enumeration of men who are cursed with misfortunes. For example, one whom his mother brought forth with weeping, and perhaps forms part of a prayer that the bridegroom may not ever be like such men. We must hope someday to find a fuller text and so to determine the connection of the various columns. But it is difficult to imagine what else the text can be than part of a wedding ceremony. The first home. The young couple did not always set up a house of their own. They often went to live with the bridegroom's father. This is shown by the penalty fixed by the code for the seduction of a daughter-in-law by a father-in-law. The daughter-in-law was living in his house. Monogamy prevalent in early days. In the earlier days, monogamy prevailed. A man ordinarily had one wife. Polygamy, however, was not unknown. For a variety of reasons, men did sometimes have two wives, but these cases were treated as exceptions. A man might also have a concubine or a slave girl to bear him children. These did not bear legitimate children. He might adopt them, but was not bound to do so. If a man married twice, the children of both marriages shared equally in his possessions, but they did not put their mother's marriage portions into a common fund and divide that equally. The children of the first wife divided among themselves their own mother's marriage portion, and the children of the second marriage did likewise. Polygamy in later times. In Assyrian times, there is clear evidence that among the slaves and serfs at least, polygamy was fairly common. In the later Babylonian era, polygamy also existed. Wives might be sisters. We read of a second wife. But taking a second wife was held to be a slight upon the first, in whose marriage contract the clause was inserted that in such a case the husband must pay her a mina of silver and allow her to go back to her father's house. In that case, the man was hardly bigamous. It was a case of divorce, and perhaps a legal ceremony before judges was also necessary. Concubinage. A man might form a connection with a woman other than his wife. A concubine was a free woman but had not the status of a wife. Nevertheless, she might bring with her a marriage portion, over which she had the same rights as a legal wife. She was taken into the same house as the wife, but she might not rival her. A man's excuse for taking a concubine was that his wife was childless. He was not allowed to take a concubine even if his wife was childless if she gave him a maid to bear him children. Only when the wife was herself childless and would not allow him a maid was he allowed to bring a concubine into his house. This second wife was married to him. She often seems to have been bound to serve the first wife and treat her as her mistress, but she had the same rights as a wife. If she were put away, the husband had to return her marriage portion, if she had any. She had the usufruct of house, field, and goods. She was not deprived of her children, but had the custody and education of them. When they entered into possession of their father's property, she shared with them, taking the same share as a child. Then she was free to marry again. It seems that in any case, the children of a concubine were full children and with the same standing as the children of the first wife. The father might dower his daughter for a concubine. She then had no claim to share with her brothers and sisters at his death. But if her father had given her no marriage proportion, her brothers must give her one at the division of his property. The maid as the wife of her master. The case was different with the maid, a slave who by her mistress's consent bore children to her master. She was still a slave, and if she rivaled her mistress or was impertinent to her, she could be put back again among the slaves, perhaps even branded. But if she had borne children, she was not to be sold as a slave. At the death of her master, she was free. Her children by him were free in any case. If her master were so minded, he might make them full sons by verbal acknowledgement. It was enough to say, "my sons." But that he had done so probably had to be proved by a witness. A family unacknowledged by the father would on his death have only a mother. In such a family, the mother was the obvious ruler. We must be on our guard against mistaking her position, or that of the concubine above, for examples of matriarchy. If she was pledged for debt, she could not be sold, she must be bought back. Marriages and inheritance among slaves. That a slave usually was married to a slave girl with his master's consent, and even by his direction, is quite the rule. Masters even went so far as to buy a slave girl to be wife to a slave. There is no reason to think that the master did not respect the slave's matrimonial rights. But the slave's wife was not always owned by the slave's master. Sometimes she was owned by a different master, or was free. There was no especial disgrace attaching to becoming the wife of a slave. A free woman might not only marry a slave, but bring with her a marriage portion as if she had married in her own rank. The man had no ancestral property, he was a son of no one. Hence, when he died, all the property to be divided consisted of what the married couple had acquired together and the wife's marriage portion. To the latter, she had full and unquestioned right. The master was his slave's heir. So the property which the pair had acquired during their married life was divided into 2 equal portions. The master took one half, the wife the other, for herself and her children. The children were all free. When both father and mother were slaves, so were the children. There was no property then for the slave children to inherit. Data from the contract, some further evidence from the contracts is worth noting here. Documents relating to marriage are not very common and may have owed their presence in the archives to some peculiarity in their form. Some are perhaps rather a memorandum that the proper formalities have been complied with. Thus, we read that A has taken to wife B, the daughter of C, from C and D, his wife, and has paid 10 shekels as terob koronatalatu to C, her father. The rest is lost. If it only laid down the penalties for infidelity on either side, this was quite normal. Fatherless girls, whenever the mother alone appears, as giving her daughter in marriage, we may suspect that the father was dead or the mother divorced. When the mother is a votary, we know that such a person was not entitled to have a daughter at all, and hence we are not surprised that the terob koronatalatu offered for the girl is small, 5 shekels or even 1 shekel. So the penalty laid upon the man for divorcing such a wife is only 10 shekels. On the other hand, if she was unfaithful, she was to be drowned. The marriage of votaries, very singular are the cases in which a votary marries. We know from the code that this sometimes took place. But the votary seems to have been expected, though married, to keep her vow of virginity. In one case we read that a woman first devotes her daughter, Ulilsi, then marries her and declares at the same time that she is vowed, alit, and that no one has any claim on her. Power of agnates. In some cases, a sister had the power to give her sister in marriage, with the declaration that no one has any claim on her. We may imagine the sisters orphans, without brothers. The name of their father is, however, given, and his sons and daughters are mentioned. It seems to be closely parallel to the case of the marriage of a king's daughter, where a sister also gives a sister in marriage. Here, Elmeshu, daughter of the king Amidatana, marriage of a king's daughter is given in marriage by Zertum, also daughter of King Amidatana, on the order of her brother Shumom Libshi. The bridegroom was Ibku Anunitum, son of Shamash Limer and Taram Shulum, his wife. The parents paid for their son only 4 shekels as terbkaro nitalatu, which Shumam Lipshi and Zertum received. If the bridegroom repudiated his bride, he had to pay half a mina. It is not clear what penalty the bride had to pay if she repudiated her husband. This is dated in the reign of Amidatana, but in which year of his reign does not appear, as the traces of the year name do not agree with any in the chronicle. It must then have fallen somewhere between the 7th and the 22nd years. Hence the father of the princess was alive at the time. Why had he no hand in the marriage? The history of the reign is not very well known. Perhaps he was away from home. His son and successor Amizaduga, whom we may imagine to have been the eldest son, does not appear in the case. Perhaps he also was away. But it is remarkable that the king never does directly take part in any contract. That is probably due to his sacred character. The young princess was not treated with overmuch consideration, judging by the smallness of her dowry. Marriage of 2 sisters to 1 man. We have a very singular case in the marriage of 2 sisters to 1 man. This has already been translated and commented upon by Meissner. inches, and sais. It is, however, too important to omit here. There are two tablets concerned with it. The first is the contract between the husband and his wives. We may render it thus. Ardi-Shamash took to wife Taram-Sagil and Iltani, daughters of Sinabushu. If Taram-Sagil and Iltani say to Ardi-Shamash their husband, "You are not my husband," one shall throw them down from the Anzag Garkai. And if Ardi-Shamash shall say to Taram-Sagil and Iltani his wives, "You are not my wives," he shall leave house and furniture. Further, Iltani shall obey the orders of Taram-Sagil, shall carry her chair to the temple of her god. The provisions of Taram-Sagil shall Iltani prepare. Her well-being she shall care for, her seal she shall not appropriate. Then followed 10 witnesses, but no date. The second document seems to be drawn up rather from the point of view of the sisters. We may render it thus. Iltani, the sister of Taram-Sagil, Ardi-Shamash, son of Shamash-Shenam, took to wife from Utatam their father. Iltani shall prepare the provisions of her sister, shall care for her well-being, shall carry her chair to the temple of Marduk. The children which she has borne or shall bear shall be their children. If Trama shall say to Iltani her sister, "You are not my sister," shall say to Iltani her sister, "You are not my sister, you are not my sister." If Iltani shall say to Taram-Sagil her sister, "You are not my sister," one shall brand her and sell her. If Ardi-Shamash shall say to his wife, "You are not my wife," he shall pay 1 mina of silver. And if they say to Ardi-Shamash their husband, "You are not our husband," one shall tie them up and throw them into the river. Here there are 11 witnesses, but again no date. Meisner deduces from the mention of children that Taram-Sagil was already married. The exact relation between the sisters is not clear. In one case, they seem to be daughters of Utatam, in the other of Sinabushu. Or it may be that Iltani alone was daughter of Sinabushu. If so, perhaps Utatam had adopted her. Sais clearly thinks so, but they might be daughters of the same mother by different fathers, one of whom is mentioned in one case, the other in the other. Or they might really be children of Sinabushu if their mother afterwards married Utatam, who was thus their stepfather. It is clear that Iltani was to wait on her sister, and if she repudiated her, was to be treated as a slave. This is exactly parallel to the status of the slave maid, whom a wife or votary in the code provided for her husband. Perhaps Taram-Sagil had become a chronic invalid. A comparison of the two texts is interesting in other respects. The penalties differ curiously. If Ardi-Shamash repudiates his wives, in one case he loses house and furniture. In the other case, he pays 1 mina. Was one the penalty for repudiating Taram-Sagil, the other for repudiating Iltani? But if they repudiate him, the penalties are different in the two documents. Unless, indeed, the Anzag Garki be an ideogram for the steep place from which they were to be thrown into the water. Marriage with attached conditions. Marriages are not infrequent, which impose conditions upon the husband and wife with relation to outside parties. Thus, a mother gives her daughter in marriage to a man on condition that she shall continue to support her mother as long as she lives. In this case, if the husband put away his wife, he was to pay 1 mina of silver, while if she hated her husband, she was to be thrown from a pillar, dindu. This pillar may be the real meaning of the Anzag Gargai, which looks very like an attempt to express ziguratu, a tower, in an ideographic way. A very similar case is where a lady takes a girl to be wife to her son but stipulates that the wife shall treat her as mistress. If she shall say to her mother-in-law, "Thou art not my mistress," she shall be branded and sold. As long as the mother lives, they two together shall support her. One may suspect that such maternal power, as is here shown over the children, arises from their having been adopted by their mother in order to provide for her in her old age. This was often done. The children may have been slaves before adoption. In the second case, the mother leaves her son all she has or may acquire.
Divorce and desertion.
Early regulations regarding divorce. Divorce is regulated by the code. The Sumerian laws seem to regard the marriage tie as dissoluble on the part of the man by an act of simple repudiation, accompanied by a solatium, fixed at half a mina. The wife, however, was punished by death for repudiating her husband. The code limits the facility of divorce for the man and renders it possible for the woman to obtain. Rights of a divorced wife. Divorce of either a wife or concubine involved her being given a maintenance. The divorced wife had the custody of her children, if any. They were not disinherited by the divorce. The divorced woman retained the marriage portion, which she had brought to the home. She had a share with her children in the divorced husband's property at his death. If he married again, the children of both marriages shared equally. She was also free to marry again, but apparently not until her children had come into their share of the late husband's property, therefore not during his life. Grounds of divorce. Divorce was permitted on the ground of childlessness. The husband gave back to his wife all her marriage proportion. Also, he had to give the bride a price which he had paid to her parents during his courtship, and which they had returned to him as a rule on marriage. If this bride price had not been given, then he paid her a fixed sum of money. 1 mina if he was a patrician, a third if he was only a plebeian. A slave does not seem to have had the liberty of divorce. Protection of the wife's rights. The wife might take a dislike to her husband and set her face to leave him and deny him conjugal rights. This was probably equivalent to desertion. Then a judicial inquiry was required. If his ill treatment or neglect was made clear and she was blameless, a divorce was granted. She took her marriage proportion and went back to her family, but as this was of her own seeking, she received no alimony. It is assumed that it was an unhappy marriage from the first, and that there were no children. If it were proved that she was a bad wife, she was treated as an adulteress and drowned. On the other hand, even if she were a bad wife, the husband might repudiate her simply without paying any price for divorce. In this case, there was no suspicion of her infidelity, or the husband might degrade her to the position of a slave. There is no mention in these cases of a return to her father's house. Chronic illness on the part of a wife was not a ground for divorce. The husband had to maintain her. He might, however, take a second wife. If she did not care to remain in his house in such conditions, she could leave him, take her marriage proportion, and return to her family. Illustrations from the contracts we have already seen that the code regulates the questions arising out of divorce. The examples at this period are but few. In one case, a man put away his wife and she received her price of divorce. It is expressly stated that she may marry another man and her former husband will not complain. This document is, however, little more than an agreement to abide by the terms of the divorce. In another case, a marriage contract names the penalty a man shall pay for divorcing his wife. In all these cases, the word for divorce, ezebu, is literally to put away. But a man divorced his wife by the simple process of saying, "You are not my wife." He then paid her a fine, returned her marriage portion, and so on, as laid down in the code. It was far harder for a woman to secure a divorce from her husband. She could do so, however, but only as the result of a lawsuit. As a rule, the marriage contracts mention death as her punishment if she repudiates her husband. The death by drowning is usually named. This was in accordance with Law V of the Sumerian Code. We may regard repudiation of husband and wife one by the other and desertion as leading to divorce, and therefore these may be appropriately considered next. Involuntary desertion. Desertion of a wife by her husband might be involuntary. The code deals with the case of a man captured by the enemy. If the wife were left at home well provided for, she was bound to be true to her absent husband. If she entered another man's house, she was condemned to death as an adulteress. But if she was not provided for, she might enter another man's house without blame. There she might bear children, but if so, she yet had to go back to her original husband on his return. The children she had borne in his absence were to be counted to their real father. That the law provides for such cases points to the existence of frequent wars, in which fortune was not always on the side of Babylonia. Voluntary desertion. But the husband might desert his wife voluntarily, then, if she was left unprovided for, the wife might enter another man's house. The errant husband, when he returned, could not reclaim his wife. We have a legal decision in a case where a man had deserted his wife for 20 years and left her to her fate, did not love her. During this time, a daughter, whether real or adoptive, we are not told, took care of her mother. To her, the mother left property, among other things, a slave. The mother being dead, the truant husband returned and claimed the slave from the daughter. He was non-suited. Among the provocations which gave the wife cause for divorce was the going out of the husband, probably a euphemism for adultery on his part. Belittling his wife was another ground for her complaint. What this means is not quite clear, but we may regard it as persistent neglect.
Rights of widows.
The authority of the widow in the home, the code makes clear what was the position of the widow. She had a right to stay on in her husband's house until she died, but was not compelled to do so. If she remained, she was the head of the family. To her, the young sons looked to furnish them with means to court a wife, and the daughters for a marriage proportion. She acted in these matters with the consent and assistance of her grown-up children, but she might elect to leave the home and remarry. Rights of inheritance. As long as she remained in her husband's home, she enjoyed to the full whatever she had brought there as a marriage portion, whatever her husband had settled upon her, and also received a share from her husband's goods at his death. The widow's share was the same as a child's, but she had no power to alienate any of these possessions. The code expressly declares that they were her children's after her. The children had no power to turn her out. If they desired her to leave, the matter came before the law courts, and her private wishes were consulted. If she wished to remain, she might do so, and the judge bound over the children to allow her to do so. Later usages, a very clear example of the permanence of the code regulations on this subject, meets us in the 5th year of Cambyses. Taht, daughter of Nabu Bela-Yusur, wife of Shamash Ubalit, son of Belabara, a Shamash priest who was dead, whose sons were Shamash Yetir Niditum and Ardiye Kara Nukar, swore to Belubalit, priest of Sippara, saying, I will not remarry, I will live with my sons, I will bring up my sons to manhood, until they are numbered with the people. On the day that Taht remarries, according to her bond, the property of her late husband, which is in the possession of Belubalit, the priest of Sippara, she shall forfeit. The tablet is defective here, but on the edge of the tablet we see that the care of her sons was given her. To remarry is expressed here by the words going into the bit zikari. Remarriage of a widow. A widow could remarry at her discretion. She no longer had to be given in marriage. She was free to marry the man of her choice. She might take with her her marriage portion to her new home, but she had to leave behind any settlement which her former husband had given her, or any share of his goods that had come to her at his death. Her family were not called upon to find any fresh marriage portion for her, but she was not completely mistress of even her marriage portion. If she had children of the former marriage, they and any children of her second marriage shared her marriage portion equally. Only she had the enjoyment of it for life. If there were no children of the second marriage, those of the first took all she left. Disposal of her first husband's property. We have assumed that when her husband died, her children were old enough to care for themselves. If they were not, she had no power to enter upon a second marriage and desert her first family. She was not free to marry at all without consent of the law court. But there is no evidence that this could be withheld if proper conditions were observed. The first husband's property was inventoried, and consent for the second marriage being granted, she and her new husband were bound by deed to preserve the whole estate of the late husband for his children. With that proviso, the newly married pair entered into full use of the deceased's property and were bound to educate the children until grown up. They had no inducement to neglect them, as in any case, none of the deceased's property could ever be theirs. If the children died, it would all revert to the family of the deceased. The newly married pair had no further interest in it than the enjoyment of it, until the children could manage for themselves. They could not alienate any of it. The sale of even a utensil was not possible.
Obligations and right of children.
Absoluteness of the paternal power over the family. It is customary to say that the father had absolute power over his children, but it is better to state only what is known with certainty regarding the extent of his power. The father could treat his child, or even his wife, equally with a slave, as a chattel to be pledged for his debts. We may therefore conclude that he could sell his child. An actual example cannot be cited from early times, but they are very common later. The son was not capable of entering into an independent contract with an outside person. We may assume that this means simply while yet living in his father's house, The father had rights over what his son earned. A man could also hire out his child and take the wages. His power of preference, the father had the right to prefer one son above the rest. He could endow him with house, field, and garden, but this must be done in his lifetime and by written deed. This gift did not in any way affect the son's claim to inherit equally with his brethren on the father's death, when he took a full share over and above what he had by gift. His control of his daughters. The father had full power to dispose of his daughters in marriage, but he was expected to furnish them with a marriage portion. This was not obligatory, being probably a matter of negotiation with the parents of the bridegroom. In later times, the obligation evidently became irksome and oppressive, and Law E was passed to relieve the strain. A father was bound to do his best to fulfill his promise to dower his daughter, but no more. A father could not hinder his daughter from becoming a votary. If he approved her choice, he might give her a portion, as if for marriage. But he was not compelled to do so. A father could give his daughter to be a concubine. The father's consent was also needed to his son's marriage. He had to provide the youth with a bridegroom and secure a wife for him. The age of majority. It is not easy to determine when children cease to be under the paternal power. Betrothed daughters remained in their father's house, so did married sons sometimes. Whether the birth of a child, making the young man himself a father, freed him as head of a family, or whether it was entering a house of his own, we cannot yet say. Punishment of unfilial conduct. The Sumerian laws are very severe upon a child's repudiation of a father, that degraded him to the status of a slave. He might also be branded. Obviously, he was disinherited. The repudiation is expressed in the words, "You are not my father," but it may be intended to cover all unfilial conduct. The code is more explicit. If a son struck his father, his hands were cut off. Disinheritance. The Sumerian laws preserved the father's rights to disinherit the son by a simple repudiation, saying, "You are not my son." The son then had to leave house and enclosure. The code limits this power. It insists on legal process, and good reason, alleged. Also, it was not allowed for a first offense on the son's part. Relations of mothers and sons, the mother was in much the same position of authority as the father. A son who repudiated his mother was branded and expelled from house and city. He was not, however, sold as a slave. The Sumerian laws also reserved to the mother the right to repudiate her son, and he must quit house and property. The code gives no such power to mothers. Indeed, we find examples of a son disputing with a mother. Mothers took up the father's place toward the children on the death of the father as regards marriage portions, bride portions, and other family affairs. But they usually acted in concert with the elder children. Duties to adoptive parents. The repudiation of adoptive parents was a very grievous sin, especially on the part of those who were children of parents who were forbidden to have children. Something worse than illegitimacy was their lot. The penalties of having the eye torn out or the tongue cut out show the abhorrence felt for their ingratitude.
The education and early life of children.
Number and importance of scribes. Much has been made of the knowledge of writing shown by the Babylonians and Assyrians. The ability to draw up deeds and write letters seems at first sight to have been widely diffused. In the times of the first dynasty of Babylon, almost every tablet seems to have a fresh tupsar, or scribe. Many show the handiwork of women, scribes. But most of the persons concerned in these documents were of the priestly rank. There is no evidence that the shepherds or workpeople could write. In the Assyrian times, the scribe was a professional man. We find Abba, or Tupsar, used as a title. So too in later Babylonian times. The witnesses to a document can only be said to sign their names insofar as that they impress their seals. This was done at any rate in early time. In the Assyrian period, the only parties who sealed were the owners of the property transferred to a new owner. The whole of a tablet shows the same handwriting throughout. Anyone who reads carefully through the facsimile copies in cuneiform texts can readily see this. Different scribes, especially in early times, wrote differently, but this was still the case in Assyrian days. Yet no change of hand can be noted anywhere in one document, save where, as in the forecast tablets, a date or note was added by a different person, often in Assyrian script, to a text written in Babylonian. The only safe statement to make is that from the earliest times, a very large number of persons existed at any rate in the larger towns, who could write and draw up documents. Sumerian words and expressions in the legal literature. The use of Sumerian terms and phrases in the body of a document written in Semitic Babylonian might be ascribed to a mere tradition, but they were no meaningless formulae. The many variations, including the substitution of completely different though synonymous words, show that these Sumerian phrases were sufficiently understood to be intelligently used. In later times, they either disappear altogether or are used with little variation. They had become stereotyped and were conventional signs, doubtless read as Semitic, though written as Sumerian. Our own retention of Latin words is a close parallel. The first dynasty of Babylon was bilingual, at any rate in its legal documents, though the letters are all pure Semitic. The earlier documents show few signs of Semitic origin, though its influence can be traced as far back as we can go. Schools. The discovery at Sippara of a school dating from the first dynasty of Babylon is very fully worked out by Professor Scheil in Une saison de feuilles à Sippara, page 30, 54. Professor Hilprecht gives further details in Explorations in Bible Lands, page 522 to 28 and Passim. The methods of learning to write and the lessons in Sumerian are well described by these authors, and illustrated by numerous extant examples of practice tablets. The subjects were very numerous and included arithmetic, mensuration, history, geography, and literature. As Dr. Pinches has shown by his edition of some of these practice tablets, these contain very valuable fragments of otherwise lost or imperfectly known texts. Apprenticeship slaves were often bound as apprentices to learn a trade or handicraft. A man might adopt a child to teach him his trade, and his duty to him was sufficiently discharged by doing so. In naming of children, we do not yet know in any authoritative way when or with what ceremonies children were named. In the case of slaves, we have a boy, still at the breast, or a girl of 3 months, not named. On the other hand, a girl still at the breast is named. Hence, Meissner concludes that at the end of 1 year at latest, the child was given a name. But the usage with respect to slaves is hardly a rule, and, as appears from the above, they were not consistently named. Rearing of babies. A child seems often to have been put out to nurse. From the phrase book, we learn that a father might give a child to a wet nurse to be suckled and give the wet nurse food and drink, oil for anointing, and clothing for 3 years. That this was not only done with adopted children is clear from the code, where we find a severe penalty laid on a wet nurse who substitutes another child for the one entrusted to her without the parent's consent. Number of children who could read and write. It will hardly do to interpret the phrase book as meaning that all children were made to learn writing, but that this was commonly done is evident from the number both of men and women who could act as scribes.
Adoption.
Frequency and reasons for adoption. Adoption primarily means a process by which parents could admit to the privileges of sonship children born of other parents. There were many reasons which might impel them to such a course. If they were childless, a natural desire for an heir might operate. But under the Babylonian law, a man might take a second wife, or a maid if his wife were childless, to bear him children. A more operative cause was that children were a source of profit to their parents while they remained with them. But it seems that men married early, hence this alone does not seem sufficient to account for the great frequency of adoption. Besides, in that case, what induced a parent to part with his child for adoption? It seems that the real cause most often was that the adopting parents had lost by marriage all their own children and were left with no child to look after them. They then adopted a child whose parents would be glad to see him provided for, to look after them until they died, leaving him the property they had left after portioning their own children. Children who might be adopted. The code admits all kinds of adoption, but regulates the custom. A man might adopt an illegitimate son, or the child of a votary or palace warder, who had no right to children, or the child of living parents. In the latter case alone was the parent's consent necessary. We have examples of cases of adoption of relatives, of entirely unrelated persons, of a slave even. We learned from the series Anna et Tisu that a man might take a young child, put it out to nurse, provide the nurse with food, oil for anointing and clothing for a space of 3 years, and then have it taught a trade or profession such as that of scribe. The method of procedure adoption was effected by a deed drawn up and sealed by the adoptive parents, duly sworn to and witnessed. Such contracts definitely state the relationship, which was in all respects the same as that of a son born in matrimony. But it laid down the obligations of the son, while it stipulated what was the inheritance to which he might expect to succeed. It brought responsibilities to both parties and fixed them. The son was bound to do that which a son would naturally have done, explicitly, to maintain his parents while they lived. The parents were bound not only to leave him property, but to treat him as a son. But, as a rule, all was matter of contract and carefully set down. If such a contract was not drawn up, although the adoptive parents had brought him up, the child must return to his father's house. Only for an artisan, it was sufficient to have taught the child his trade. So far as our examples go, some color might be given to the suggestion that adoption was always merely for the convenience of old people who wanted to be taken care of. But we know that children were adopted on other grounds. That they were children and not always grown-up men and women is clear from the above. This we may regard as adoption pure and simple. Other cases are a legal method of making provision for old age, or for other purposes for which an heir as legal representative was desirable. In the case of no legal heir, the property went back to the next of kin. Adoption pure and simple, that such a process did take place in Babylonia, is made clear by the code. But few examples are known where a father takes into his family an additional child. The case in which the son is not only adopted by parents who have a family living, but is ranked as their eldest son, deserves reproducing in full. Ubar Shamash, son of Sinadinam, from Sinadinam his father, and Betitum his mother, have Beltum Abi and Taramumash taken to sonship, and let him be the son of Beltum Abi and Taramumash. Ubar Shamash shall be their eldest son, the day that Beltum Abi, his father, and Taramumash his mother say to Ubar Shamash their son, "You are not our son. He shall leave house and furniture, the day that Ubar Shamash shall say to Beltum Abi his father, or Taram Umash his mother, You are not my father or my mother. One shall brand him, put fetters upon him, and sell him." Both parents of the adopted son were living. That the son is to be reckoned eldest implies that the adopting parents had other children. This is made clear in one case where the adoptive parents are expressly said to have 5 children. In another case where a child is adopted, a certain person is expressly said to be his brother. Consent of other members of the family involved. The existing members of the family had a real interest in the proceeding, for, as inheriting with them, the addition of another son could not but affect their prospects. We may wonder what influenced them to consent. That they did consent is clear from the often occurring covenant by which they bound themselves not to object. One explanation may be that they had grown up and left home and were anxious for the welfare of their parents, but could not arrange to look after them themselves. Hence, for their parents' sake, they were willing to forego their share, or submit to a stranger taking precedence of them, or in some cases to give up all claim to the property in their parents' possession, in return for being relieved of the responsibility of looking after them. Of course, when the adopted son was only taken in as one, even the eldest among several, he would only have a share at the parent's death, but it even seems that the children might of their own motion adopt a brother to be son to their parents. Disinheritance of a son. The clause which implies disinheritance in case the parents repudiate the son, or he repudiates them, could only be enforced by a law court. But it was nevertheless most regularly inserted in the contract. In one case, the document merely consists of it, leaving us to infer that an adopted son was concerned. But this is not absolutely certain. The son might have been rebellious to his mother, who was therefore minded to cut him off, and this may be the result of her bringing her son before the judge. The judge was bound to try and conciliate the parties. Hence, not infrequently the son was bound over not to repeat the offense on pain of disinheritance, while the mother retained her right to disinherit. There was no mention of his being sold for a slave or branded, as was usual when a son was adopted and then repudiated his parents. According to the contracts entered into by the parties, parents could repudiate adopted sons. This was contrary to the law by which the consent of the judge was needed for disinheritance. It seems to be an attempt to contract without the support of the law. The son was then to take a son's share and go away. Form of adoption. The word aplutu, abstract of aplu, son, and therefore literally sonship, being also used to denote the relation of a daughter to a parent, came to denote the share which a son or daughter received. If a man adopted a son, he granted him an aplutu, or sonship, and this carried with it a material property. But the father, while still living, might grant the son his aplutu and stipulate for maintenance during the rest of his life. Such a grant begins with aplutu sa B, where B is the son, but it by no means follows that B is an adopted son. The question is only decided for us when the parentage of B is given. If he is said to be the son of C, then we know that A giving him sonship must mean that A adopted him. But if B is merely indicated as the son of A, we cannot tell whether he was born to A or only adopted by A. Phrases which express the idea, so when the property given to B is in his power to dispose of later as he may choose, this privilege is expressed by the words, he may give his sonship to whom he chooses. The choice is sometimes expressed as that which is good to his heart, or in his eyes, or whom he loves. A modified choice is often mentioned as when it is said that a votary may leave her sonship after her to whom she likes among her brothers. Settlements which assume adoption. We have a large number of documents which make reference to the aplutu of a certain person, which we can render here by heritage. These are especially common on the part of votaries. As we have seen, they were not supposed to have children of their own, but possessed the right to nominate their heir within limits. In return for exercising this right in favor of a certain person, they usually stipulated that such person shall maintain them as long as they live and otherwise care for them. Even outside actual deeds of heritage, we find references to property derived from votaries. Such dispositions of property are closely related to a will or testament, but anticipate the death of the testator. They are really settlements for the future, which exactly answers to the title given them by the Babylonian scribes, Redit Warkati. The following example makes these details clear. The heritage of Elearisa, votary of Shamash, daughter of Shamash Ilu, Belasunu, votary of Shamash, daughter of Nakarum, is the caretaker of her future life. 1/3 gan of unreclaimed land in Karnum Karum next the field of Isuria, 1 sar house in Hakarum Ukub Karonala, next the house of Nakarum, 1/3 sar forgin in Gagim, 1 maid Shalabeltum, price 10 shekels of silver, all this for the future in its entirety. What Elearisa, votary of Shamash, daughter of Shamash Ilu, has or shall acquire, she gives to Belisunu, votary of Shamash, daughter of every year Belasunu shall give to Elearisa 3 gur of corn, 10 minas of bronze, and 12 kb data taliska of oil. Precautions against suisu. The applitu thus given was in many cases an alienation of property on which some relative had claims. Even where their consent was not necessary, it was desirable that they should not involve the heir in legal processes. Hence, such relatives are called up to covenant that they will raise no objection to the heir's peaceable succession. Duties of adopted child to parents. Support. The obligation to support the adoptive parent is emphasized. The amount of sustenance varies much. Another list of yearly allowances reads 1 shekel of silver, woolen yarn, 6 kb dotiliska of oil, 4 isini shamash, 10 kb dotiliska of fat, 1 side, 2 gur of corn. Many others could be instanced, but they make no great addition to our knowledge. Service. The obligation might be service, as when a lady adopts a maid to serve her for life and inherit a certain house. In another case, a lady adopts a son to bring up her daughter and give her to a husband. If he vexes his adoptive mother, she will cut him off. He shall not have claim on any of the goods of his adoptive mother, but shall inherit her field and garden. Evidently, the mother intended her personal effects to be her daughter's and to form her marriage portion. The obligation did not always last long. Thus we find that Lautum, who was adopted by a votary and was herself a votary, 2 years later was in a position to adopt as her daughter another votary. She handed on the same property, indicating that her adoptive mother was dead. The adoption of a child by a lady of fortune was evidently a good settlement for the child, and usually the real parents raised no objection. We even find the father of a girl adopted by a lady making an addition to her heritage in the form of a gift to the adopting mother on her effecting the deed of adoption. He gave them 2 male and 2 female slaves. Here also, the girl covenanted to support the adoptive mother. Punishment for neglect of these duties. Occasionally, the adopted child did not carry out his duties. This was good ground for disinheriting him. But disinheritance was not to be inflicted without the sanction of the judges. Hence, we find that when a lady had adopted a daughter who failed to give her food and drink, the judges summoned them to the great temple of Shamash in Sippara. There cut off the daughter from her heritage, took away the tablet of adoption granted her, and destroyed it. Care of aged parents. A curious case is where A, the daughter of B and C, endows D to take care of B and C. As long as D lives, a covenants to allow her so much. When she dies, A will herself perform the duties. Here, A evidently expected her parents would not live long, but also D must have been aged or infirm, as A contemplates the chance of her parents outliving D. This is not a case of adoption, but is so similar in purpose to those above as to deserve a place here. Inheritance rights. Occasionally, however, the adopting parent reserved the usufruct of the property for life only, fixing by deed the rightful heir. This was, in effect, a will or testament, since the inheritance did not take effect until after the death of the testator.
Rights of inheritance.
The division of an inheritance, the division of property among the children, invariably followed the death of the father. We have a very large number of contracts bearing on this custom. The contract sets forth the particulars of the division and includes a sworn declaration on the part of the recipients to make no further claim. There were certain reservations to be made in the case of minors, for whom a portion had to be set aside to provide for their making the proper gifts to the parents of their brides on marriage. Usage is illustrated by the contracts. The code deals at length with the laws of inheritance, which are best treated under the head of marriage. The actual examples occurring in the documents of the period serve to illustrate the practical working of these laws, but hardly add to our knowledge. They are usually occupied with the division of property among brothers. Sometimes we have some light on the reservations made in favor of other members of the family. Thus, 2 brothers divide the property of their father's house and of their sister, a votary. The sister did not take her property, but the brothers were trustees for her enjoyment of it during her life, when it reverted to them in full. The document merely states the amount of one brother's share and the other's agreement to be content with the division. In another case, where 4 brothers share the property of their father's house, no details of their shares are given, but only their agreement to abide by the division made. In another case, the eldest brother allots to each of 2 younger brothers a share, and takes a woman slave and her children as his portion. He is said to do this of his own power, ina emurkedoti talamanisu, and to have given them this of his own graciousness, ina tubatisu. The brothers swear to make no further claim on the grant, marsitu, of their father. Either the property to which they were legally entitled had already been allotted them, or possibly they had no legal claim on any. The eldest brother is a high official, a papa, and perhaps had succeeded his father in office. The father's property would then be the endowment of his office, a grant from the king, and as such inalienable from the office to which the eldest son had succeeded. The 3 slaves may have thus been all the private property of the father which was available for division, but the context seems to suggest that what the brothers received was a concession from the eldest brother on which they had no claim. He may, in consideration of his succeeding to his father's appointment, have made this concession to his brothers as a consolation. In another case, a mother gives certain sums to her 3 sons. She had still left 2 sons and 2 daughters, and the first 3 agree to make no claim on all that she and these 4 children have or shall acquire. It is noteworthy that one of the 3 receives 10 shekels as the tereb karana talatu of the wife he shall marry. He was evidently not of marriageable age, or at any rate still unmarried. In such a case, the code directed that on partition of the father's property, a special sum should be laid aside for this necessary present to the bride's father. So we find 2 brothers giving a sister a share consisting of 1/3 of a house next her brothers, 1 maid, a bed, and a chair, with the promise that on the day that she marries and enters her husband's house, she shall receive further 2/3 gan of land and slaves. The list of property is often given, especially where brothers give shares to their sisters. Sometimes the relationship is less close. Thus, a man shares with 2 sons of his father's brother, i.e., with 2 cousins, 10 sar of unreclaimed land, taking 3.5 sar as his share. Sometimes the property included the mother's marriage portion. Thus, 3 brothers divide their property and 2 of them, as her sons, share their mother's marriage portion. Division of property between 3 brothers. 1 sar of built land and granary, next the house of Ubaria, and next that of Busham. Sin, 2 exits to the street, the property of Uranasir, which he divided with Sinikishem and Ibni Shemash. From mouth to gold the share is complete. Brother shall not dispute with brother. By Shemash, Malkat, Marduk, and Sin Mubalit they swore. 9 witnesses. 13th year of Sin Mubalit. The property which fell to Ura Nasir was a house occupying 1 sar of land. The text means not that the 3 men, Ura Nasir, Sinikisham, and Ibni Shemash, divided the house among them, but that at the division this house was the share of the first named. What the 2, Sinikisham and Ibni Shemash, had as their share we are not here told. But the 3 agreed not to call in question the division of property which probably came to them from their father or mother. Fortunately, we know in this case what the others got. Thus we find 1 sar of built land and granary, next the house of Ibni Shamash, and next the street, its exit to the street, the property of Sinik Kishem, which he divided with Ibni Shamash and Ura Nasir. From mouth to gold the share is complete. Brother shall not dispute with brother. By Shamash, Mokat, and Sin Mubalit they swore. 9 witnesses. 13th year of Sin Mubalit. And again, 1 sar of built land and granary, next the house of Sinikisham, and next the house of Istar Umasha, 2 exits to the street, the property of Ibni Shamash, which he divided with Sinikisham and Ura Nasir. From mouth to gold the share, shall not dispute with brother. By Shamash, Malkat, Marduk, and Sin Mubalit they swore. 9 witnesses, 13th year of Sin Mubalit. Thus, we see that each brother, if they were brothers, obtained exactly the same share, 1 sar of land on which a house was built. 2 of them, Sinikisham and Ibni Shamash, were next door to each other. Ibni Shamash had the street on the other side of him, in fact, occupied a corner house. The 3rd brother, Ura Nasir, had a house in another part of the town. We therefore must understand the word divided in the sense obtained on division. In the 2nd and 3rd case, the word rendered share is literally all, but the first text shows that all is complete means the share is complete. The meaning of the expression from mouth to gold is still obscure. It is not certain that by-e really means mouth, but as Meissner has shown, it exchanges with the ideogram for mouth. He therefore suggests that the whole phrase means, from the first verbal discussion of the division to its consummation by payment, the partition of the property is now at an end. That seems probable enough, but we may yet find a different explanation. If this be correct, it is of interest to note that while silver seems to have been the usual money, this phrase seems to assume that gold would be used in payment. A curious parallel is the fact that while in later times we always find the order gold and silver, in Sumerian texts it is silver and gold. We must not press this too far, but it really looks as if in early times silver was more valued, or at any rate less in use, than gold. It will be noted that the 2nd text omits Marduk from the oath, while the others name him. The 3rd text omits Gamru, is complete. The 9 witnesses and the date are the same for all 3. In the 1st and last, the names of the witnesses only are given, but in the 2nd, the name of the father is added to several of them. The great difficulty of interpreting details in testamentary documents. In the case of testamentary documents, using the phrase in a loose way to cover gifts embodied in a deed, we usually find a list of property donated. These lists give rise to insuperable difficulties to the translator. The difficulties are not so much due to the imperfections of our knowledge of Babylonian methods of writing, as to the practical impossibility of finding exact terms in one language for the terms relating to domestic furniture in another. Even in the case of languages so well known to us as French and German are, we are obliged to transfer their words unaltered into our own tongue. The most skilled translator must leave a French or German menu untranslated. We know, for instance, that the signs gis, gweza were used to denote the Babylonian kusu. When a god or king sat upon a kusu, we may be satisfied with the rendering throne. But when we find a lady leaving her daughter 6 kusus, we feel that throne is rather too grand. But whether we elect to call them chairs, stools, or seats, we are guilty of some false suggestion. A careful examination of the sculptured and pictured monuments may give us a clearer idea of what seats were used. The reader may consult Perot and Chipiez or the dictionaries of the Bible under the articles chairs, couches, etc. for illustrations. Unless we can find a picture with a named article upon it, we are still left a wide margin of conjecture. The picture of Sennacherib receiving the tribute and submission of Lachish gives the contemporary representation of a kusu nemeru, but we cannot argue that every kusu was of the same pattern. We may decline to attempt a solution and merely give the original word. We may make a purely arbitrary rendering, or we may accompany the original word with an approximate indication of what is known of its nature. In neither case do we translate, for that is clearly impossible. But the reader needs a word of caution against the translations which show no signs of hesitancy. They are not indicative of greater knowledge, but of less candor. Further, to scholars, a reminder is needed that even the syllabaries and bilingual texts do not give exact information. Thus, alongside Jiskuza, we find a number of other ideograms, all of which are in certain connections rendered kusu, adequately enough no doubt, but that they all denoted exactly the same article of furniture is far from likely. A closer approximation to an exact rendering may come with the knowledge of a large number of different contexts, each of which may shade off something of the rough meaning. One of the great difficulties of the translator is that the same word often occurs again and again, but always in exactly the same context. This is especially the case in the legal documents, filled as they are with stock phrases. Disinheritance in the Sumerian laws. According to the Sumerian laws, disinheritance appears to have been simply the result of repudiation of a child by a parent, who has said to him, "You are not my son." The penalty for a child's repudiation of parents is to be reduced to the condition of a slave. There may also be a reference to renunciation on the part of an adopted child, but there are no legal documents to clear up the point. In the code of H.K. Karen U.C. Kamarabi, the code is much clearer. Here, the father is minded to cut off his son, but the disinheritance must be done in legal form. The father must say to a judge, "I renounce my son." The judge must then inquire into the grounds of this determination. A grave fault must be alleged. What this was, we are not told, but rebellious conduct, idleness, and failure to provide for parents are probable. A parent had the right to his son's work. An adoptive parent had a right by the deed of adoption to maintenance. If the fault could be established as a first offense, the judge was bound to try and reconcile the father. If it was repeated, disinheritance took place legally. It was done by a deed duly drawn up. The Sumerian laws show that a mother had the same power as the father. Whether this was only exercised when there was no father, or whether a wife could act in this way independently of her husband in disinheriting children, does not appear. But possibly she had power in this respect only over her own property. It has been suggested that disinheritance sometimes took place as a legal form and with consent of a child in order to admit of his adoption into another family, or to free the parents from responsibility for the business engagements of the son. In the case of adopted children, an adoptive parent who had brought up a child and afterwards had children of his own could not entirely disinherit his adopted child. He was bound to allow him 1/3 of a child's share, but he could not alienate to him real estate.
The slavery.
The slave, a chattel. In modern thought, slavery concerns personal rights, but it was not thus regarded by the Babylonians, for the slave was an inferior domestic and, like the son in his father's house, minor capitis. That he was actually a chattel is clear from his being sold, pledged, or deposited. He was property, and as such a money equivalent. He might be made use of to discharge a debt according to his value. Hence, while some account of slavery belongs with the discussion of the family, it is also a part of the section dealing with property, since the slave was a piece of property. rights of a slave, but the slave had a great amount of freedom and was in no respect worse off than a child or even a wife. He could acquire property, marry a free woman, engage in trade, and act as principal in contract with a free man. Only, his property at his death fell to his master. He was bound to do service without pay, though he had the right to food and drink. He could not leave his master's service at his own will, but he might acquire enough property to buy his freedom. He was tied to one spot, not being allowed to leave the city, but might be sent anywhere at command. Complexity of the evidence regarding slavery. His status was, however, a complex of seeming inconsistencies. Yet it was so well understood that we rarely get any hints as to the exact details. It is only by collecting a vast mass of statements as to what actually occurred that we can deduce some idea of the actual facts. Professor Oppert, in his tract La condition des esclaves à Babylone, Comptes Rendus, 1888, pp. Level Day, and Comptes Rendus, 1888, 11ff, and Dr. B. Meisner in his dissertation De Servitude Babylonico-Assyriaca, have gathered together the chief facts to be gleaned from the scattered hints in the contracts. Professor Kohler and Dr. Peiser discuss the question thoroughly in their Ostbabylonische Rechtsleben. Many articles discussing the contracts, and most of the histories touch upon the subject. We shall come back to it later under the head of sales of slaves. It is very difficult to disentangle facts from the mass of scattered hints, often consisting of no more than a word or two in a long document. Its very early existence. The institution of slavery dates back to the earliest times. We cannot in any way attempt to date its rise. Already in the Stele of Menestusu, we find a slave girl used as part of the price of land and worth 13 shekels, while 9 other slaves, male and female, are reckoned for 1/3 of a mina apiece. This remained a fair average price for a slave in Babylonia, down to the time of the Persian conquest. For the variations, see later under sales of slaves. The code shows that the slave was not free to contract except by power of attorney, and that it was penal to seduce him from his master's service, or to harbor him when fugitive. It fixes a reward for his recapture, makes it penal to retain a recaptured slave, and deals with his re-escape. It shows that he was subject to the levy. It also determines the position of a slave woman who bears children to her master, or of a slave who marries a free woman. In each case, the children are free. It fixes the fees to be paid by the slave's master for his cure, deals with injuries done to a slave, damages being paid to his master. Enacts that if captured and sold abroad, he must be freed, if repatriated, and a native of Babylonia, otherwise he returned to his master. Sale of slaves. By far the greatest number of references to the slave condition occur in documents relating to the sale of slaves. These may be summarized here. One peculiarity always marked the sale of a slave. It was not so irrevocable as that of a house or field. For a slave might not be all he seemed. He might be diseased or subject to fits. He might have vices of disposition, especially a tendency to run away. A female slave might be defective in what constituted her chief attraction. Hence, there was usually a stipulation that, if the buyer had a legitimate cause of complaint, he could return his purchase and have his money back. In fact, an undisclosed defect would invalidate the sale. These defects might be physical, inherent, contingent, or legal. Diseases regarded as just cause for a repudiation of the contract to buy a slave. There seems to have been a dreaded disease called the Benu. Professor Jensen has shown how largely it bulks in the literature and what dire effects are ascribed to it. But it was not the only severe disease from which men suffered then. It is associated with several others as bad. Hence, in legal documents, we may take it as a typical example of a serious disease which would so detract from the value of a slave that the purchaser would not keep him. It is evident that it was something that the purchaser could not detect at sight. Perhaps it was a disease which took some time to show itself. It is mentioned in the Code and in the sales of slaves of the first dynasty of Babylon. It also occurs in Assyrian deeds of sale down to the end of the 7th century BC. The Code and the contemporary contracts allow 1 month within which a plea could be raised that the slave had the Benu. The purchaser could then return him and have his money back. In the Assyrian deeds, 100 days is allowed. In the Assyrian deeds, Sibtu is also allowed 100 days. This is often associated with Bennu in the mythological texts as equally dreaded. It affected the hands or the mouth. We may render it seizure and think of some form of paralysis. Legal defects. The objections, which come under the head of legal defects, are summed up in the code as a bagru, or complaint. In the contracts and code, this could be pleaded at any time. So in Assyrian times, a sartu, a vice, could be the ground for repudiation at any time. This might arise from the disposition of the slave. The sale might also be invalidated by a claim on him for service to the state, by a lien held by a creditor, by a claim to free citizenship. But we are not yet in a position to state definitely what was the exact nature of these claims. Doubtless, the recovery of further codes will fix them finally. In later Babylonian times, law B specially provides for the return of the slave at any time if a claim be made on him. Assyrian usages regarding slaves. In Assyrian times, sales of slaves are very frequent, and we learn much more about the status of the slave. The slave was certainly a social inferior, but probably had more freedom than any other who ever bore the name. He certainly had his own property and could contract like a free man. A young slave lived in his master's house up to a certain age, when his master found a wife for him. This was usually a slave girl. The female slaves remained in the house as domestic servants to old age, unless they were married to a slave. Married slaves lived in their own houses for the most part. Many such men seem to have taken up outdoor work, gardening, agricultural labor, or the like on their master's estate. Others engaged in business on their own account. But from all, the master had a certain income. This was, within a little, the average interest on the money value of a slave, and that interest was usually 25% per annum in Assyria. Right of a slave to the enjoyment of his property and family. Theoretically, a master owned his slave's property. What this ownership amounted to is hard to say, but the slave was rarely separated from it. His family, at any rate, was sacred. When sold, he was sold with his family. This, of course, does not exclude the sale of a young man at a time when he would naturally leave his father's home. Young women were taken into domestic service and after a time sold, but there was none of that tearing of children from parents which so shocked people in the modern examples. It is probable that a slave could not marry without his master's consent. He certainly could not live where he liked, but he was free to acquire fair wealth, and his property was so far his own that he could buy his own freedom with it. The serfs. In Assyria, there was a large body of serfs, Galiba adscripti. They could be sold with the land, but they were free to work as they chose. Usually they cultivated a plot of their masters, but often had lands and stock of their own. They were not free to move and probably paid a rent, 1 or 2/3 of their produce. But they were mostly on the metayer system and could claim seed, implements, stock, and other necessary supplies from their master. This class evidently possessed privileges highly esteemed, for their ranks were recruited from all classes of artisans in the towns: cooks, brewers, gardeners, washermen, and even scribes. Some of these were probably free men, others certainly had been slaves. Advantages of slavery. The three classes, domestic slaves, married slaves, and serfs, were continually exchanging their condition. Not a few free men, whether from debt, judicial sentence, or choice, were added to these classes. For these men, if dependent, were cared for and provided with the necessaries of life. They were, if domestic, clothed, housed, and fed. If they married and lived out, they were given a house, and either were provided with land that brought them a living, or engaged in business. Liability for forced labor. The Armenian corvée, or levy for forced labor, were chiefly obtained from the slaves and above all from the serfs. A head of a family or mother was not liable, but young men and women had to serve a certain number of terms of service, seemingly 6. Hence, it was of importance to the buyer of a slave to receive a guarantee that this claim had been satisfied. Opportunely to acquire skill as artisans. We have many examples of slaves who were skilled artisans. They had been taught a handicraft. Later, we shall come across cases of apprenticeship of slaves to learn a craft. But all the artisans were not slaves. Indeed, some of the craftsmen, as goldsmiths, silversmiths, carpenters, were wealthy persons. The slave an independent asset. As a rule, though the slave is named, his father is not. But, just as in medieval times, a serf's father is named. The serf's holding seems to have been hereditary, but we have too few examples to be sure of our ground here. The slave's father was not concerned in the sale, and that may be the sole reason why he is not named. Such sales are not so unnatural as they appear. It was a sure provision for life for a child to sell him as slave to a family in good position. The later disappearance of the serf, in the later Babylonian times, the almost total disappearance of the serf has been noted as very remarkable. But this may be entirely due to the nature of our documents. The temples owned a great deal of land, and their slaves were in the condition of serfs. Slave sales. In later Babylonian times, we have a very large number of examples of slave sales. So far as the formula of a deed of sale is concerned, there is nothing to distinguish from a sale of the ordinary type, thus marking the slave as a chattel. Guarantees exacted in such deeds, but there are several clauses which directly illustrate the possession of slaves, their position and liabilities. One clause, frequent when slaves were either pledged or sold, was a guarantee on the part of the owner against a number of contingencies. These are not easy to understand. Against rebellions, first we have the Emelu Sib Karanai Talu. Sib Karanai Talu means rebellion or civil war. Sennacherib was slain in such an uprising. It may be that then the slave would be impressed for defense of law and order, or it may be that Amelu Sib Karonatalu is the rebel or mob who might carry off the slave. Or the contingency contemplated may be that the slave should turn rebel and refuse to do his master's bidding. The fact that a ship was also guaranteed against Amelu Sib Karonatalu renders this less likely. A ship could not turn rebel. It is not unlikely that slaves often joined in the rebellions. Against flight, that a slave would escape by flight was always a danger. The slave had great freedom and many opportunities of getting away. The only security was that, wherever he went, he was likely to be recognized as a slave and anyone might recapture him. However, the captor had a right to a reward, and so the owner would have to pay to get him back, besides losing his services for a time. Hence, a slave who had a fancy for running away was likely to be troublesome and costly, that might lead to his being sold. But the purchaser protected himself by a guarantee on the seller's part that the slave would not run away. Then, if the slave fled and was brought back, the captor gave a receipt for the sum paid him and the owner reclaimed it from the seller. The captor might retain the slave until he was paid. In other cases, the seller had to recover the slave for the buyer against untimely death. In Assyrian times, the seller guaranteed also against death. Here it has been argued that the guarantee meant only that the slave had not fled or was not dead at the time of sale. This is not likely in the case of death. Surely no man could buy a slave who was dead. He would not pay if the slave was not delivered, but he might bargain for recompense if the slave died within a short time after purchase, as the seller might have had reason to know that he was ill. Against unexpected claims, a guarantee was also given against the pakaranu. This is literally the claimant. What claim he had is not stated. When the slave was pledged, this might be a creditor to whom he had previously been pledged, but it covers all claims on the slave. Against over-exaction in the public service. Another indemnity is the arad sarutu, or in the case of female slaves, the amat sarutu. This was the status of an arad sari, or amat sari, king's man or maid. The king or state had a right to the services of certain slaves. How long this was for, how it was discharged, and how a private person could give a guarantee against it, we do not exactly know. It may have been limited to slaves taken in war. It probably consisted in forced service. It may have been for a limited period, so that the guarantee amounted to an assurance that it was over, but it is possible that it would be compounded for, or a substitute provided. At any rate, the seller held the buyer indemnified against this claim. Against redemption as men of family, there was also a guarantee against mar banutu, the status of a mar banu or son of an ancestor. The difficulty which this raised was that if a man was a scion of a noble family, he might be redeemed by it. The same result would follow from his being adopted, hence some consider mar banu to mean adopted son. But it does not always mean that. We have no good example of a slave being redeemed on this ground, but we know that they sometimes laid claim to be free men. This would, of course, involve a loss and at any rate a trouble to the owner, but we have not yet very full information on the point. Against illegal enslavement, finally there is mentioned a claim called Susunutu. This occurs in Persian times only, and may be the status of a Susanu, i.e. a Susian, or one of the conquering race. Such it may have been illegal to buy or hold in slavery, but in Assyrian times an official in the service of the royal house is called Susanu. We do not yet know what his duties were, but it may be that this official was one who could be called up for service at any time, and therefore was undesirable as a slave. The branding or tattooing of slaves, the abatu which the code contemplates a mistress putting on an insolent maid, and so reducing her to slavery, or which the phrase books contemplate a master laying upon a slave, or which an adoptive parent may set on a rebellious adopted son before selling him into servitude, has usually been taken to be a fetter. But in the case of a man who, being sold as a slave, had escaped and was claimed by the levy master, we find the latter saying alita abutaka gulobat. Thy abut is clearly branded or tattooed, hence it may only be a mark. The other ways of indicating servitude. There is frequent mention in early times of a mark upon slaves. The code talks of marking a slave, but in a way that is difficult to understand. The verb usually rendered brand has been shown by Professor P. Jensen to include incised marks. Hence, the penalty which was once rendered shear his front hair is thought to mean brand his forehead. The code fixes a severe penalty for the putting of an indelible mark on a slave without his owner's consent. This could hardly be enforced for merely giving the slave a bald forehead, like the Hebrew piot, or like a tonsure. The mark borne on the forehead by Cain, or by the sealed in the Apocalypse, is far more to the point as a parallel. The slaves also wore little clay tablets with the name of their owner inscribed upon them. There are a number of these preserved in the Louvre. On one now in the British Museum, we have this inscription: Of the woman Karen Yusipi, who is in the hands of Sinaresh, Sabat, 11th year of Merodach Baladan, king of Babylon. How these were attached to the slave is not very clear, but they must have been anything but an indelible mark. In the later Babylonian times, we have a slave marked by a sign on his ears and a white mark in his eye. Both may denote natural marks. A more definite example is a slave whose right hand has written upon it the name of Ina Sagili Labur, and another on whose left hand was written the name of Meskitu. These were the names of the owners, not of the slaves themselves. This renders it probable that the branding and the like was always an incised mark, a species of tattoo, which of course was indelible. That the same person who tattooed men should brand animals, or even shear them, is not an insuperable objection. But there is no reason to suppose that the brander ever was a sheep shearer. Significance of slave names. In respect to the names of slaves, we may regard them with some interest as helping to determine the sources from which slaves were recruited. Some bear good Babylonian names, and perhaps when the father's name is also Babylonian, we may conclude that they had been born free, but were either sold into slavery by the head of the family, or, having once been adopted, had been repudiated and reduced to slavery again, or had been sold for debt. We have examples of all such cases. A father and mother sold their son. A mother who had adopted 2 girls repudiated them again. A brother gave a younger brother as a pledge. Foreign-born slaves. When the slave's name is not Babylonian or Assyrian, a foreign nationality is nearly certain. These names are very valuable when they can be assigned to their nationalities as confirming the historical claims of the kings to conquest. Sometimes they are actual Gentile names, as Mizrai, Egyptian, Tubalai, man from Tubal. But many may have been directly purchased abroad and sold to Babylonians. A great many foreign slaves doubtless received native names. Thus, an Egyptian woman was called Nenaitia. Some of the names of slaves are true Babylonian, but of a rare and odd form, which has caused some to imagine them to be foreign. But this is not necessary. Servants are often renamed after the families to which they belong, and finally become known by names which were never theirs. Masters seem sometimes to have given their own names to slaves. Their names are often contracted, and some even appear to have had 2. Various methods of making slaves. The slaves were not only captives taken in war, but were bought abroad, and not a few were reduced to that condition from being freeborn citizens. Slavery awaited the rebellious child or the contentious wife, but it was not allowed by the code for a man to sell his maid outright who had borne him children, and if he sold his wife or child to pay a debt, the buyer could not keep them beyond a certain time. But in all periods, parents sold their children, and there does not seem to be any clause demanding any future release. A slave's right to hold and use property. The slave had private property which was secured to him. He paid a sort of rent for it. This was an annual fixed sum called his mandatu, the same word as for the tribute of a prince to his overlord. In the case of a female slave, this was 12 shekels per annum. Further, he paid a percentage on his profits. The slave might hold another slave as pledge, lend money, and enter into business relations with another slave even of the same house. He might borrow money of another slave. Hence, he was very free to do business. But when he entered into business relations with another master's slave or a free man, he sometimes met with a difficulty. He seemingly could not enforce his own rights against a free man. At any rate, we find that in such cases, his master assumed the liability and pleaded for him. In fact, the master had to acknowledge his undertakings, though he did not guarantee them. Subject to this protection from his master, the slave was free to engage in commerce. He lent to free men, entered into partnership, and owned a scribe. A slave's evidence not good against a free man. Here is an example illustrating one of the above points. X had taken a loan of L. His master, A, became aware of it and guaranteed its repayment. He then put S into L's hands as his pledge to pay it off. Now, A died, and his son B sells S to C as part of his own property. But L still holds possession of S. C demands S from L. L says, "Not until my money is paid off. If C will do this, he may have S." The proof probably lay in B's hands if he had preserved it from his father A's records. Delay is granted for C to produce the proof that S has worked off the debt. It is clear that the evidence of S was not admitted on this point. A slave's value proportioned to his producing power. That in the case of some slaves their value to their master consisted in their mandatu is clear from the fact when a master sold a slave and did not at once hand him over, the seller had to pay a proportional amount of this fee to the buyer. Of course, in transferring a slave to another owner, the seller could not separate him from his property. That was his own. A slave who had acquired a fair amount of wealth or was earning well in trade would produce a higher income to his master and sell for more. What was sold then was an interest, the master's, in his slave's work. Hence, prices varied very much. We are not always able to see what was the reason of the high price, but it was evident then to those who made the bargain. An average price in the later Babylonian era seems to have been 20 shekels, the interest on which at the usual 20% would be 4 shekels. This then was the annual value of a slave above his keep. If the keep amounted to about 8 shekels per annum, that gives the value of a slave's work as 12 shekels yearly. This is what an unskilled slave was worth to his master. If, then, a man married a slave girl, he ought to pay her master about 12 shekels a year for his loss of her services. Of course, the master retained his right over her, but it seems to have been a tacit understanding that he could not sell her away from her husband. So really, what he sold was, after all, only a right to income from her husband of 12 shekels a year. The children were also his born slaves, if the father was his slave. We do not know how matters would be arranged if the man was slave to one master, the wife to another. Probably this was provided against by the master giving his slave a wife from his own maids, or buying a slave girl as wife for him. The history of the slave Bariki Elu. It occasionally happens that we can trace the history of a particular slave for some time. Thus, Bariki Elu was pledged for 28 shekels to Ab-Karanin Nuri in the 35th year of Nebuchadnezzar. In the next year, we find him in the possession of Piru, his wife Gaga, and a cousin Ziria. What they gave for him does not appear, but they now sold him for 23 shekels to Nabuzardukin. He must have fled from his new master, for 4 years later, the same 3 people pledged him. But he seems to have been unsatisfactory as a pledge. For next, we find that Gaga's daughter, Piro having probably died, being about to be married to Idinaplu, this slave was set down as part of her marriage portion. She gave him over to her husband and his son. In their possession he remained a while, but on the death of his mistress was handed over to the great banker Idi Marduk Balatu. These events, extending from the 35th year of Nebuchadrezzar to the 7th year of Nabonidus, were all put in evidence when Bariki-Olu tried later to prove that he was a free man. He pretended to be the adopted son of Bel-Ramani. He had to confess that he had twice run away from his master and had been many days in hiding. Then he was afraid and pretended to have been an adopted son. This, if proved, would have freed him, but he confessed that it was a pretense and had to return to his servitude. The case was decided in the 10th year of Nabonidus. A runaway slave not always returnable. It seems clear that when a slave ran away to his old owners, they did not always deliver him up again to the man who bought him of them. They probably had to return the purchase money. The buyer probably would not accept him again. Apprenticing slaves to a trade. One feature which the later Babylonian contracts show us for the first time, but which probably was always in force, is the apprenticing of slaves to a trade. Instances of this are fairly numerous. The person to whom the slave was apprenticed was usually a slave himself. The teacher was bound to teach the trade thoroughly. The owner of the slave gave him up to the teacher for a fixed term of years, differing for different trades. He had to furnish a daily allowance of food and a regular supply of clothing. At the end of the term, the slave might remain with his teacher on payment of a fixed mandatu, or income, to the owner. Penalties were fixed for neglecting to teach him properly. The trades named are weaving, 5 years term, baking, 1 year and a quarter, stone cutting, 4 years, fulling 6 years, besides others not yet recognized. Fee paid by service. The teacher had no fee, but only the apprentice's work for his trouble. The owner was therefore bound to allow the apprentice to remain a fair time. Relative proportion of slaves to free men. A question of considerable interest which needs to be worked out is the relative number of slaves in the population. In early times, the impression one gets is that they were few. Even in the time of the first dynasty of Babylon, the evidence at the disposal of Dr. Meissner in 1892 did not allow him to exceed 4 as the number in the possession of one man at a time. But since then, further evidence is available. Thus we read of 12 slaves at once, 7 males and 5 females, given by a father to his daughter at Sippara. In Assyrian times, the number in an average household rarely exceeds 1 or 2, but we have as many as 30 mentioned at one time. So in later times there are generally only 1 or 2 in a household, but the number is occasionally much more. Price of a slave. As to the value of a slave, we have in very early times an average set down as 20 shekels, with examples as low as 13 shekels. In the time of the Second Dynasty, prices varied from as low as 4.5 shekels for a maid, or 10 shekels for a man, up to 84 shekels. The code estimates the average value of a slave as 20 shekels. In Assyrian times, the price of a single male slave varies from 20 to 130 shekels, but the usual price is 30 shekels. A female slave could be had for as little as 2.5 shekels, but might cost as much as 90 shekels. A common price was 30 shekels. In later Babylonian times also, prices vary widely, but the commonest price and usual pledge value was 20 shekels.
The army, corvée, and other claims for personal service.
The levy there was always a militia, landwehr, or territorial levy of troops. Each district had to furnish its quota. These are called sabeh, or ummanit. We have no direct statements about them, but a great multitude of references. They were called out by the king, adki ummanitia. I called out my troops is a stock phrase. The calling out was the dekutu. Not easily to be distinguished from this was the Sisitu of the Nagiru. That officer seems to have been an incarnate war office. It is not clear whether he always acted solely for military purposes. The levy seems to have been equally made for public works. The men were the king's men, whether they fought or built. The obligation to serve seems to have chiefly affected the slaves and the poorer men, the muskanu. In the code of Eth Karu, U Kamarabi, It was punishable with death to harbor a defaulter from this levy. Forced labor claims might also be made for work on the fields. This was called Hach Coronatarium Lev Isu, and we know little about it, more than that Sargon II charged his immediate predecessors on the throne with having outraged the privileges of the citizens of the old capital, Assur, by putting them to work on the fields. The obligation to provide a soldier for the state was tied to a definite plot, or at any rate to all estates of a certain size. The ilku, or obligation of the land, was transferred with it. In Assyrian times, the military unit was the bowman and his accompanying pikeman and shield bearer. The land, which was responsible for furnishing a bow, K Bidal Titla, exemption of certain cities. Some cities claimed for their citizens a right of exemption from the levy. In Sargon's time, we find that cities like Ashur had been subjected by Shalmaneser IV to this service, and Sargon restored their rights. He freed them from Dikutu Mati, Sisitu Nagiri, and Miksu Kari. The city had not known the Ilku Dupsiku. Later, we find an officer, Tabsil Isara, complaining that when he was desirous of doing some repairs to the queen's palace in Ashur, of which city he was Saknu, Sargon's freeing of the city had rendered the Ilku of the city unavailable to him. In the so-called Tablet of Warnings to Kings Against Injustice, the cities of Borsippa, Nippur, and Babylon are freed from Dupsiku and Sisu to Nagiri. This was drawn up in the time of Ashur-banipal, but whether it was original with him is not clear. At any rate, later, under Cambyses and Darius, these cities were again subject to the levy. Classes subject to the levy. This obligation to perform forced labor or serve in the army fell on the agricultural population primarily. Indeed, it seems that the men who discharged it might be called upon to do field labor, and it was an aggravation of the insults put upon the old capital Ashur that its citizens were set to do field labor. On all country estates there were a number of serfs, kliba ad scripti, sold with the estate, but not away from it. These, as the H.B. Karen Ukankan Karen census shows, often had land of their own, but they were bound to till the soil for the owner. They included the irisu, or irrigator, the husbandman in charge of date plantations, gardens, or vineyards. From these were drawn the men who served in the army as kingsmen and on public works. They seem to have been liable to 5 or 6 terms of service, seasons' work probably, or campaigns, and then were free. At any rate, the heads of families seemed to be free. The daughters as well as sons were subject to service, probably to repair to the great weaving houses in the towns. Service at the royal weaving establishments. We read of these weaving establishments from early times. M. Thoreau Dengen has called attention to their occurrence in the Tello tablets of the Second Dynasty of Ur. The amounts of wool assigned to different cities to work up are the subject of many tablets. In the great cities, the temples or the palaces were the home of this industry, but quantities of stuff were served out under bond to private establishments to be worked up and returned or paid for. The work on these industries constituted the amat saruti, or obligation to serve as king's handmaid. It lay also upon slaves. It is doubtful whether the obligation included domestic service. From the Second Babylonian Empire, we have a host of tablets relating to these weaving accounts. They will be found fully discussed by Dr. Zandfund in his Weberrechnungen. Obligations of slaves to the state. The married slave, even in the city, usually lived in his own house. His children were born to slavery, but were usually not separated in early life from their parents. They entered their master's service and might be sold when grown up. They might learn a trade and so earn a living, paying a fixed sum to their master. They might become agricultural laborers and so attain a fixity of tenure as serfs. But on all these subject classes, slaves, whether domestic or living out, serfs, and artisans, there lay the obligation to do forced work for the king. After a certain number of terms of service, they were exempt. Public obligations, the obligations to public institutions, which existed in Babylonia in later times, have not yet been made the subject of a thorough study. Kohler and Pizer have noted several of the more important indications, and to them we owe what has been done up to the present. To take a share in the expense of warfare. The most noteworthy obligation was what they called the Kebi Dote Talablu, This has the same sign as so commonly used in the phrase kebi dote talablu utakaroni talazu for war and fighting, but it is also the ideogram for sisitu, the call of the Nagiru to war, or the corvée. There is no doubt that it indicates the levy for war. The Riki's kebi dote talablu was the money due from certain persons to furnish a soldier for the war. Thus, we have 70 shekels paid to a certain man in the 5th year of Darius to go to the city Shiladu. Again, a certain Beledin had to find 25 shekels to pay a substitute to go for him to the presence of the king. Another man paid the wages of a soldier for 2 years. This was an os militare. In another case, we find the rikis kebidot itailabli for a horseman for a certain troop for 3 years. It consisted of an ass worth 50 shekels, 36 shekels for its keep, 12 coats, 12 breastplates, 12 musapalatum, 12 leather mitu, 24 shoes, 30 kebidotiliuka of oil, 60 kebidotiliuka of delelium, 60 kebidotiliuka of some aromatic, all as equipment cititum to go to the camp. This may be described as os equestran. So, the burgomaster of Babylon paid rikis kebidotolabli for 3 years for a certain soldier, receiving the amount from single citizens. How this arose, what dues it was a composition for, and whether it antedates Persian times are details not yet clear. To pay dues for the land. Besides the personal obligation to contribute work, dolu, a liability for contributions in kind, ilku, dues from the land existed. We are in the dark as yet as to the exact form these took. In the code, the ilku, or duty from an estate held as the benefice of an office, was the fulfillment of the functions of the office. The word does not seem to denote contributions, but the word literally is what comes of any holding, income, or what is taken from it. In a charter of Melashib Koronu, we have a long list of powers which could be exercised by the king's officials over land. They are levies or forced contributions of wood, crops, straw, corn, wagons, harness, asses, or men, rights to abstract water from canals, to drink from the water, to pasture herbage, or set on the royal flocks or herds, to pasture sheep, to construct roads or bridges. These are referred to as either a dulu or ilku. The governor is named as likely to demand right of pasture for his flocks and herds, or work for roads and bridges, but we are left without information as to the proportion these levies bore to the property. All we can conclude is that the king had a right to impress such things or such labor. Few, if any, other documents are so full and explicit as to the dues exacted from the land, but all these dues are mentioned, again, 1 or 2 together, in almost all the charters. The temple tithe. This is one of the most important dues from land. It was paid to the temple. Some are inclined to see it in the nisertu, from which many charters exempt land, but others consider this merely a word for diminution or levy in general. There is no means of deciding yet as to the time at which the tithe first became a fixed institution. In Assyria, there seems to be no trace in Assyrian times of any payment of a tithe. The tithe rab esrite, which has been rendered tithe collector, is more likely to be a commander of 10, a decurion, common among Neo-Babylonians. The evidence for the existence of tithe in the later Babylonian period is very full. All seem to have paid it, from the king downward. Nabonidus paid on his accession to the temple at Sippara 5 minas of gold. It was a very large sum, but may have been a sort of succession duty rather than an income tax. It is curious that we also find Belshazzar named as paying tithe, due from his sister, and that when the Persian army was already in possession of Sippara, this shows that the Persians were friendly invaders and respected the rights of private property and of the temples. Belshazzar also paid tithe through his major domo to Bel, Nabu, Nergal, and Belit of Erech. Often paid collectively, it was paid for a group of persons by one of their company, or perhaps we might say that certain persons collected tithe from their district and paid it in. Thus we have a document recording the payment by one man of the tithe due from a number of shepherds, cultivators, and gardeners in the city of Mahbakaronaz Shamshi. In the time of Artaxerxes I, Hilprecht has shown that in some cases the bow of land also paid tithe. Usually in kind, tithe was usually paid in kind on all natural products: corn, oil, sesame, dates, flour or meal, oxen, sheep, asses, and the like, but also was liquidated by a money payment. The tablets relating to it are very numerous, but in nearly every case amount to no more than a receipt for its payment. Tithe became property apparently and was negotiable, so at least appears from Nebuchadrezzar 270, we thus have property in income from land. Octroi duties, the various dues, mixu, seem to have been a sort of octroi duty. They were levied at the quay, mikisu kari, at the ferry, mikisu nibiri. They are only mentioned in the charters, granting exemptions from them to certain estates or their owners. Closely related to these were the mikisu, which seemed to be some sort of due or tax levied upon all naturalia, and even upon the dues which were paid into the temples. We have frequent mention of them in later times, in the temple accounts.
Land tenure in Babylonia.
Distinction between real and personal property. The idea of real as opposed to personal property is common in Babylonian law, for we notice that in the code, while certain persons may inherit from the goods of their parents, they may not inherit land, garden, or house. He then had no share in his father's house. He was not one of the family. The distinction is important for, as we shall see later, the word house had a wider signification than mere bricks and mortar. It was the ancestral estate. Over it the family had rights. It went back in default of heirs to the family of the last owner. We are therefore confronted with private ownership of land, but also with a sort of entailed property. The amount of land might be increased by purchase, but there is a strong presumption that it thus became family property and did not remain at the disposal of the buyer. For if so, in the case above, the law should have stated that the parent could not donate land that was family property, but might do so with what he had bought. This does not exclude the possibility of sale. Only the family had apparently the right of preemption. Natural features of Babylonia in their influence on property rights. In looking back upon the primitive state of the country, its natural features must be taken into account as helping to shape the course of development. In such a low-lying country as the land between the Euphrates and the Tigris, floods naturally occur every year. Every spot of land that stood above the level of the annual floods was thereby marked out for a residence. Throughout the literature of Babylonia, the hill or the mountain is a refuge and a place protected by the gods. But when the floods were gone, man's great need for his land was water. Hence, irrigation was synonymous with cultivation. The unclaimed land grew rank with grass and natural food for cattle, but dried up to dust in the summer. Hence, the control of the flood, its diversion into desired channels, regulation, storage, and all the processes implied by canals and irrigation were forced upon the inhabitants of Babylonia by stern necessity. The only alternative was to migrate with flocks and herds to higher lands when the floods came. Primitive land tenure settled society was ultimately founded upon the cultivation of a plain. Every eminence might become a hamlet occupied by the abodes of men, whose fields were water meadows. The meadows which grew their corn lay around the village and below its level, and beyond those which were needed to grow crops lay the pastures. But for security, the cattle and sheep must come back before the floods came to the village, there to be folded and fed, as it seems, upon straw and also grain. The land of the village extended itself in time as the population grew and needed more corn. More and more of the unreclaimed land beyond the cornfields was brought into cultivation, and the flocks went farther afield for pasture. This continued until the pastures forming the outlying ring had met the pastures of another village. Ownership of cultivated land. Such is an ideal sketch of the growth of land tenure. But in historical times, this simplicity had vanished. Land was owned, not merely held. It does not appear that pasture was owned even as late as the first dynasty of Babylon. It seems that the flocks were confided to shepherds, who were bound to bring them back from the pastures and expected to account for all they took out and for a reasonable increase in the flock from breeding. The pasture was common land, at any rate to the sheep owners of the same village. No one claims to buy and sell pasture land, only cultivated land, but unreclaimed land, that is, such as only required cultivation to make it fields and gardens, is often sold or let to be reclaimed. Was this a trespass on the pasture held in common? If so, it was not resented as such. We do not know yet how a man acquired a title to such unreclaimed land. Perhaps to have brought it into cultivation sufficed originally to establish title, theoretical ownership of the land by the local deity. A settled hamlet soon had its temple. Some think that the god was ideally landlord of all the village land and that every title represented simply the rental of the land from the nominal owner. We do indeed find the temples as owners of vast estates, and, like monastic institutions in the Middle Ages, letting lands and houses. To the temples, poor men went for temporary accommodation for sowing, for wages at harvest time, and for ransom from the enemy. These they had a right by custom to receive without paying interest. Undoubtedly, the temples became the first centers of progressive civilization. The patesi, as chief priest of the god, was the regent of the community. In process of time, as villages combined and grew into towns and districts, the patesi, in virtue of his town's supremacy, became the king, who, as regent of the state and representative of the gods, owned all. We know that, in later times, the king in Babylon was the adoptive son of Bel-Merodach. Private ownership absolute in historical periods. In historical times, no such conditions prevail. Doubtless, the tribal ownership had become theoretically transferred to the god or to the town. That the town had a theoretical personality of its own is clear enough from the oaths sworn to confirm a sale. Men swore by the gods, the king, and also by Sipra or Ker Sipra, but there is no indication that points to the god or the town or the king as having any power to intervene to prevent a sale or to claim payment for consent. It is clear that the land was sold subject to its dues, and they were many. But the private ownership, subject to such reservation, was absolute. The one danger to a purchaser was that the family of the seller should claim a right of redemption and annul the sale. Against this, the seller undertook to indemnify him. Right to retain ancestral estates. Exact statements as to the rights possessed by the family to reclaim land sold by a member of the family are not to be found, but they are to be inferred with certainty from a few notices which we have. Thus, a man claimed a certain plot of land as ancestral domain, which two others had sold. There are several such cases among the legal decisions of the first dynasty of Babylon. In most of the Assyrian deeds of sale, we have a long list of representatives of the seller who are explicitly bound not to interfere and attempt to upset the sale. Their right existed, or they would not be called upon to enter into a contract not to insist upon it. Different kinds of real property. From the point of view of the ancient Babylonian, as from that of the modern lawyer, there was a great similarity about all classes of real property. The deeds of sale, or conveyances, as well as the leases, treated them with much the same formula. It was the land which was the main consideration. It was as land, built upon indeed, but essentially as land, that the house was sold. The house is rarely described by what to modern views would be its most important features: the number of stories, rooms, conveniences, and the like. Instead, its area was stated. This is remarkable, as we do not buy houses by the area. We need not suppose that the building actually covered all the land sold. In fact, we often see that it had a garden, but it was bitu epsu, a built-on plot of land, according to the Babylonian conveyancer. Perhaps there was, in this usage, a recollection of how fast the Babylonian house of sun-dried brick sank down to a mound of clay. Perhaps, too, a far-off echo of the nomad's scorn for the town dweller. In both cases, a recognition that the land was the one thing permanent, the one thing that could not run away. Terms used in descriptions of real property, the plot of land was the bitu, Hebrew beth, represented by the Sumerian e. When it had the additional advantage of a house upon it, it was bitu epsu, a built-on plot. Gradually, the edifice, in towns at least, absorbed the whole significance, and in common parlance, bitu meant a house, but in legal phraseology, it always retained its inclusive meaning of the plot of land. Even as late as the Assyrian Empire, it retained some shade of a still earlier meaning, that of a plot, parcel, or share, just what it meant when the first settlers divided the land among them. Thus, one might use bitu of a lot of slaves, or of a lot of land including its slaves and cattle, that Bitu is to be referred to a root, banu, to make, may still be true, though banu cannot have come to mean build when Bitu was formed from it. If Bitu was originally the house, perhaps only a tent house, then it could mean all that constituted the house, the man's house in a wider sense, as in tribe names like Bit Adini, or the phrase House of Israel. But Bitu, when used of a house, does not carry with it the implication of bricks and mortar, only of a fixed site occupied for dwelling. The edifice was implied by the addition epsu, marking the site built upon. So a house was landed property. Land was of various sorts, one of which is built on land. To be accurate, one must also specify the kind of building. The field was called Ektotetalu. Compare Aseldama, the field of blood, denoted by the Sumerian Asag Ga. The term does not denote open wasteland, but a cultivated plot. Indeed, it is probable that its Sumerian name implies irrigation. In any case, it was fenced, if only by a raised ridge. It was cultivated and watched over. The birds were scared away, robbers and stray animals driven off. So much, at least, is expressed in as many words in the undertakings of tenants to treat a field properly. The field was also bitu as land, usually bitu. So much ekboda tital. The garden was reckoned as land, but here a fuller specification was needed. For a plot of land, a garden, kiru, was not exact enough. It was usual to designate further of what sort it was, whether vegetable garden, orchard, or palm grove. The scribe would even add planted with such and such a crop. The term might include vineyards. In many cases, the actual number of bushes or fruit, trees, or vine stalks would be named, but it was always primarily land, and as such bitu, with the qualifications enumerated. Systems of land measures. 1. Computation by area. For land measures, there were two systems in use, one purely aerial, the other with a reference to the average yield. In the former case, the scale of measures was discovered and formulated by Dr. G. Reisner in the Sitzungsbericht der Berliner Akademie, 1897, p. 417, f, and is completely known. We do not know how these words gan, sa, jin, si were read. They may be ideograms or Sumerian words. There was also a very large measure of area, 3,600 gan, perhaps called a karu. Monsieur Thoreau-Dangan has further shown that the sar was the square of the measure gardu, which seems at one time to have measured 12 u. The u is often taken to be a cubit, but seems at this time to have been 990 millimeters, which is sometimes called a double cubit. On these suppositions, the sar would be a square, each side measuring about 22 yards, about 1/10 of an acre, or 4 ares on the metrical system. Computation by an average yield. The other system applied to land the names of measures of capacity used for measuring crops. We read of so many gur and kebedo toidol ska of land, where 1 gur equals 300 kebedo toidol ska, as shown by Dr. Reisner. We may guess that a gur of land was so called because it took a gur of corn to sow it, or because it yielded a gur of corn as an average harvest. These are mere guesses, and we must remain in ignorance until further evidence connects a gur of land on one side with its length and breadth, or some other relation between the gur and the gan can be deduced. Then we shall want to know the size of the gur of corn, of which at present we have no knowledge. But already in Susa, a broken pot has been found with its original contents marked upon it. When others are found, from which an approximate estimate of contents can be made, and an inscription read giving the capacity, we shall be able to make a definite statement. At present, the data are insufficient, and what the metrologists write is only ingenious speculation. Descriptions and plans of plots of land. A piece of land had, so to speak, an individuality of its own. Once marked out, and that probably from time immemorial, it was rarely divided. It seems probable that corn land, at any rate, was divided into long, narrow strips. But the plots became gradually of all sizes and shapes. As the many plans of estates show, the links of the sides are usually given on such plans, and much labor has been expended with small result on reconciling the given dimensions with the area ascribed to the plot. But it is certain that these were often recorded merely for purposes of identification. The area of the field was well known, and its average crop also, without any need of resort to calculations. Boundary stones. These plots often bear their owner's name, and that long after he had passed away. The boundary stones of the field were sacred. Not a few were inscribed with some sort of history of the plot. Especially was this the case when the land was granted to fresh owners by sale or charter. No inconsiderable portion of what we know of history is derived from inscribed boundary stones. They are the oldest monuments and rarely deeply buried. Hence, they are easy to find. They have even been brought to London as ship's ballast in times before they could be read. They would be invaluable if found in situ for a modern survey of the country and a reconstruction of its ancient history. As a rule, they are splendidly preserved. Inviolability of landmarks. In ancient days, great importance was attached to their preservation. The kings taxed their powers of cursing in order to terrify men from removing their neighbor's landmark. The dangers to the stone contemplated were its removal to another place, its being thrown into the water or into the fire, its being built into a wall, being buried in the dust, placed where it cannot be seen, put in a house of darkness, erased and overridden with other records. Encroaching on the highway, akin to the crime of encroaching upon old landmarks, was that of building upon or otherwise encroaching on the highway. To do this might subject the builder to the danger of being hanged, as a warning on a gallows erected above his own house. The king's power over land, that the land was sold subject to certain territorial obligations, we can glean from many hints. One of the most important is that, when a favorite or a well-deserving official had acquired a large estate, the king by charter granted him an immunity from these obligations. These charters were often inscribed on large blocks of stone or water-worn pebbles of great size, and seem to have been set up as boundary stones. Some were reproduced from tablets written on clay. They are very numerous, and in some periods of the history are the only monuments that have reached us. A glance through any history of Babylonia will show the reader how much depends on them. But here, our only concern is with the light they throw on land tenure and its conditions. One of the points which at once becomes clear is that, although the king was representative of the god and titular head of all the tribes, he could not appropriate land just where he chose. Mengistu, king of Kish, when he was seeking to acquire a fine estate to present to his son Mesalim, had to buy land at what seems to have been an average price. He paid for the land in corn at 3 1/3 gur of corn per gan, the gur being worth 1 shekel of silver. This was the price. But, as was usual later in private purchases, a present to the former owner was given. The list of these presents is most interesting, silver and copper vessels and rich vestments being the chief items. Of great importance is the reference to the leading men of each hamlet as sellers. The king's own land was a definite area, so definite as to be cited as a boundary. Recognition of private rights of possession. A celebrated passage in Sargon's Cylinder says, "According to the interpretation of my name, Sharu Kenu, righteous king, which bade me observe right and justice, repel the impious, not oppress the weak. As the great gods had bidden me, I gave money for the pieces of land of each city, according to written contracts, in silver and bronze to their owners, in order to do no injustice, and to those who would not take money, a field for a field, where they preferred I gave." That this was no idle boast is proved from the tablet which records how Sargon, in the year BC 713, having taken possession of some lands in Maganuaba to form part of his new city of Dur-Sargon, found that he was displacing an old endowment given by a deity Nirari to the god Ashur. It was held by a family descended from the original recipients. Sargon increased their holding and charged it with an increased monthly offering to the temple. He gave field for field, but also added largely to the endowments. He acted much the same in Babylonia, where the Suti had encroached upon the lands of the people. He drove out the invaders, restored the lands, but laid them under obligations, kirinutu, making them render a monthly due to the temples, as before. Royal grants to temples and favorites. On the other hand, we find that the kings granted large grants of land to temples and private persons. From what source these grants were made does not appear, probably from his own personal property. The property so presented was free of imposts, but we may not assume that the king was always the poorer. the beneficiary may have bought the land and presented it to the king to be received back free of imposts in perpetuity. Thus, Nazi-Maritash presents a large estate to Merodach and another to Kashakti Shugab, his servant. Kurigal-Zu granted an estate to Etir-Marduk for his conduct in a war against Assyria, and Batiliashu confirmed it. A coppersmith who fled from the land of Ebkaran Ukana-Galbit made a fine specimen of his work for Batiliashu, and the king rewarded him with a grant of land. Adadi Shumusur made another grant of land to an unknown servant of his. Melishahad Karonu made a grant of land to his son Merodach Baladan Fa-Yel and granted it exemption from all imposts. Another grant he made to a servant of his. So when Shamu and Shamua, his son, two priests of Iriah in Elam, fled from their own king and took refuge with Nebuchadnezzar I, he espoused their cause, plundered Elam, brought back their god Iriah to Babylon, and they, having taken the hands of Bel, the king granted them an estate in Babylonia and freed it from imposts. Nabu Aplu Idina granted an estate to a namesake of his, which, however, seems to have been claimed as ancestral property. Melishib Karigronu granted lands to H.B. Kargronu, a servant of his. Merodach Baladan I granted lands to Marduk Zakir Shumi. Marduk Nadin Ab Karoni granted Adadi Zerakisha for his services against Assyria lands in the district of Bit Ada, which seem to have been ancestral domains of one Ada. Some fragments of clay copies of similar grants by Adinarari, Tiglath-Pileser, Ashurbanipal, and Ashur-Yetilalani are preserved in the British Museum's collections from Nineveh. They all appear to record grants to favored officials who had deserved well of the king. Restoration of ancestral estates. The king also appears as not only confirming grants made by his predecessors, but as restoring ancestral property or temple endowments, which had come into other hands on suit of the legal descendants of the original owners. Thus, certain land which had come into the possession of Tarimana Ilishu and Yurbilat Mubalatat Mituti was claimed by Marduk Kudur-Usur in the reigns of Adadi Shumedina and Adadi Nadinab Karoni, and finally granted him in perpetuity by Meleshib Karonu. The land which Gulkashar, king of the sea land, gave to a goddess had remained in her possession 696 years, until, in the time of Nebuchadrezzar the governor of Bitsin Magyar, had secularized it. Belnadine Apli restored it, granting of especial privileges. A rather different grant was made by Nebuchadrezzar I to Reti Marduk for his services against Elam. This faithful vassal had been governor of a district on the borders of Elam, but the privileges of his country had been much curtailed by neighboring king of Namar. They were now restored and apparently augmented. They were that the king of Namar had no right of entry, could not levy taxes on horses, oxen, or sheep, nor take dues from gardens and date plantations, could not make bridges nor open roads. The Babylonians, or men of Nippur, who came to live there, were not to be impressed for the Babylonian army. Further, the towns of the district were freed from dues to the Babylonian governors. Marduk Nadin-Ab Karoni, in his first year, remitted some obligations on an unknown estate. Temple endowments of another kind are the monuments recording the actual endowments of temples by certain kings. A very fine example is the stone enclosed in a clay coffer, referring to the endowments of the temple of Shamash at Sippara. It records the restorations made by Simash, Shib-Karonu, Ilmash Shahin Shem, Nabu Aplu Edina, and Nabu Palasar at wide intervals. There are, however, no lands concerned. In illustration, a very archaic tablet in the E.A. Hoffman collection of the General Theological Seminary, New York City, published in the Journal of the American Oriental Society, which seems to be older than the celebrated Blau monuments, and which Professor G.A. Barton would date about 5500 BC, deals directly with the presentation of land to a temple. In it, the area of the land is given in gan and the sides in figures only, probably denoting the lengths in U, being written in very archaic, semi-picture writing, and some of the signs not yet being identified with certainty, it will not do to build much upon it. All the sides but one appear to be 36,050, that one being 36,000, while the full area is 3,005 gan. This gives the gar as roughly equals 15 u. The métier system land was let under a variety of systems of tenure. The métier system was one of the most common and persistent. The use of this term is justified by the similarity of actual cases to what is known to prevail in Italy under this name. It is a cooperative system. The landlord not only allows his land to be cultivated for a consideration, but finds the means to meet expenses. He provides bullocks, tools, seed, and many other things according to the usage of the locality. Illustrations from the code in the code of H.P. Caroni, Hammurabi, we have proof of the existence of the system a man finds. His tenant tools, oxen, and harness, but hires him to reside on the field and do the work. Actual examples are rare among the contemporary contracts, but Amat Shamash, a votary, let out 6 oxen, among them 2 cows, an irrigator, Amel Adadi, 2 tenders of an ox watering machine, his nephews, 3 watering machines for oxen, a female servant who tended the machines, half a gan of land for corn growing, to Gimalu and Ilushubani. They shall make the yield of the field according to the average. They shall cause the corn to grow and measure it out to Amat Shamash, daughter of Marduk Mushalim. In the time of harvest they shall measure out the corn to Amat. In spite of several obscurities due to uncertain readings, which render the translation doubtful in places, this must be regarded as a good example of the kind. From the Assyrian period. There are fewer data from the Assyrian period, but the frequent loans, Anna Pub Coronitali, without any interest at seed time or harvest, may be due to this relation between landlord and tenant. From the Persian period, the best example is to be found in the time of Cyrus, where a certain Shula proposes to take the fields of Shamash, in the district of Bareilly, in the county of Sippara. It was 60 gur of corn land. The temple was to find him 12 oxen, 8 laborers, literally irrigators, 3 iron plows, 4 harrows, or hoes, and 5 measures of seed corn, which also included food for the laborers and fodder for the oxen. At the end of the year he was to hand over 300 gur of corn as the temple share. Another good example from the time of Artaxerxes I relates to the assignment of 2 trained irrigation oxen and 7 gur of corn for seed by a member of the Murashu firm to 3 brothers, who undertake to pay 75 gur of corn per annum for 3 years. It does not appear that they hired the land as well. Here the hirer returns more than 10 times his loan as yearly rent. The system of shares, the usual method of hiring land, was on shares. The code contemplates that this would be for a proportion fixed by contract, either 1/2 or 1/3 of the produce going to the owner, in the case of a field or irrigated meadow, and 2/3 in the case of a garden. The difference was due to the fact that in the former case, the owner furnished the land only, possibly with its water supply. In the latter case, he also furnished the plants. In the contemporary contracts, we have but few cases where the crop is shared. In these cases, the owner and tenant share equally. The tenant was also to erect a manab karana tatu, or dwelling. It was needful that he should reside on the property to take care of the crop. This was stipulated for, and the clause added that he should hand over the dwelling to the landlord. For such dwellings, compare the cottage in the wilderness of Isaiah L8. Duties of tenants. The tenant, of course, was bound to cultivate the land. The duties which fell to his share were to plow, harrow, weed, irrigate, drive off birds, but these duties are but rarely stipulated. The code protects the tenant, however, from any unfair compulsion in the matter, so long as the landlord gets his fair rent. Fixed rental fields were also let at a fixed rent, usually payable in kind. The contracts of the first dynasty of Babylon give a large number of examples of this sort. The kinds of field are distinguished as Absine, or Seru, and Kedan. The average rent for the former was 8 gur of corn per gan, of the latter 18 gur per gan. The former class may include land with corn standing upon it, or simply corn land. The latter land as yet unbroken or fallow. The latter class seems to have been much more fertile. This rent later became more fixed, because the average yield per area was set down in the lease, and the yield in corn was estimated in money according to the ordinary value of corn. Thus, the rent is stated to be so much money. Improving leased land was often let to reclaim or plant. The code lays down as law what was evidently a common practice. In the case of wasteland given to be reclaimed, the tenant was rent-free for 3 whole years. In the 4th year, he paid a fixed rent in corn, 10 gur per gan. Land let to be turned into a garden was rent-free for 4 years. In the 5th year, the tenant shared the produce equally with the landlord. Contracts illustrating this form of lease are quite common in the time of the first dynasty of Babylon. Manorial obligations. Freedom from various obligations might be granted by royal charter. In fact, it is from these charters that we know of the existence of the obligations for the most part. The land so freed was called zaku. Land sold is often said to be zaku, and we may suppose it was so because it had once been freed by charter. But this is not quite certain. The charter was granted to a person and his heirs. Doubtless, as long as they held it, it would be free, but it is not clear that they could sell it as freed forever. But we only know that some land was free. On whom then fell the obligations? So far as they were due to the king, they may have been abolished, but such obligations as repairs of the canal banks must surely have been taken up by others. If not, the granting of charters must have been a fruitful source of trouble and distress to the land. Their basis in the obligation of fair maintenance. The obligations were of various kinds. Some were directly extensions of the duty of a tenant to exercise proper care of the estate. A very prominent duty was the care of the canals. To see that they were kept in proper order was the mark of good government. To allow them to fall into disrepair was probably the result of weak government, or the exhaustion due to defeat in war, but it very soon led to the impoverishment of the country. The code contemplates the care of the canal banks or dikes as the duty of the landowner adjoining. It holds him responsible for any damage done to the neighbor's crops by his neglect to close a breach or leaving the feed pipe running beyond the time needed to water his field. But the canal was also liable to silt up or become choked with water weeds, and the care of dredging it out was that of the district governor. He might carry out this duty by summoning the riparian owners to clean out the bed of the canal, or by a levy for the purpose. Soldiers, or at any rate forced labor, might be used. Later, in the time of Nebuchadrezzar I, we find men hired for the purpose, called kebidotitalalinari, or canal laborers.